morning, everybody. I want to welcome everybody to this confirmation hearing on the nomination of Judge Neal Gorsuch. And he's nominated to be Associate Justice of the Supreme Court of the United States. Judge, welcome to the Senate Judiciary Committee. This is a big day for you and your family. You've been before this committee once before for the confirmation hearing to the 10th Circuit where you now sit. I imagine that this hearing may be a little better attended than the last time you were here. Yeah. Before we begin, I would like to give you the opportunity to introduce your family and anybody else you want to introduce.
Senator, this is quite a lot different than it was the last time I was here. Okay. I appreciate all the attention. I would like to introduce my family who are here.
Yes.
My wife, Louise, who, as you remember, stole the show in the East Room the day I was nominated.
Okay. Yes.
I've got here somewhere, I'm told, in the audience, my brother-in-law's folks, Bill and Priscilla Albright, and my nephew, Jack. How you doing, Jack? Yeah. I've got my cousin, Meg Hopkins, and her daughter with her, Laurie. I've got a bunch more family coming. My daughter's watching back home in the West. I've got my longtime assistant, Holly Cody. Where's Holly? There she is. 10 years we've worked together. I consider her family. And I've got a whole bunch of my law clerks here in the audience. And if they wouldn't mind just standing up for a second, I'd like to recognize them because I consider them family too. So, Senator, I'm very blessed to have so many family here with me today. Okay. And thank you.
Thank you. We thank you, Judge. We're delighted to have your family here as well for this very important moment in your life. Before I give my opening statement, I want to set out a couple of ground rules. I want everyone to be able to watch the hearing without obstruction. If people stand up and block the view of those behind them or speak out of turn, it's not fair or it's not very considerate to others. So officers will immediately, under our rules, remove those individuals. Now I'd like to take a minute to explain about how we're going to proceed. We'll have 10-minute rounds of opening statements. The ranking member and I may go a minute or two over the 10 minutes, but I'm going to ask everyone else to limit your remarks to 10 minutes, and I hope everybody on both sides of the aisle will respect that. We will then turn to our introducers who will be formally presenting the judge. Then we'll administer the oath to the judge, and we'll close today's portion of the hearing with the judge's testimony. Tomorrow morning, we'll begin at 9:30 for the opening round of questions. Each senator will have 30 minutes for the opening round. After the first round, the senators will have 20 minutes for a second round. And as finally, as I have discussed with ranking member later today, we'll notice a markup to consider the judge's nomination for next Monday, the 27th. In anticipation of his nomination will be held over for 1 week, as any senator has that right under our rules to do so. We'll then vote on his nomination the following Monday, April 3. With that, I would turn to my opening statement and then to Senator Feinstein for her opening statement. One of Justice Scalia's best opinions begins with this declaration. It is, quote, the proudest boast of our democracy that we have a government of law and not of men, end of quote. The phrase comes from the Massachusetts Constitution of 1780. This infant state constitution linked the government of laws and not of men directly to the separation of powers. Justice Scalia said the founders, quote, viewed the principle of separation of powers as the absolutely central guarantee of a just government, because without a secure structure of separated powers, our Bill of Rights would be worthless, end quote. In plain words, it was a desire to preserve and protect liberty and self-government that guided the framers as they designed our Constitution. As the founding charter they designed is a remarkable document, as we know. The Bill of Rights, of course, preserve liberty by restricting what the government may do. But the single most important feature of our Constitution isn't any particular enumerated right or even the entire Bill of Rights taken together. The most important feature of our Constitution is the design of the document itself. That design divides the limited power of government vertically between state and federal governments, and it distributes power horizontally between co-equal branches. It is this very delicate balance of power entrusted to competing factions that ensures that liberty for the people will endure. It's the Constitution's design that protects against the mischief that results from the concentration of political power. The founders understood this fundamental principle, and Justice Scalia understood it better than anyone. He was fond of telling law students, quote, every tin-horn dictator in the world today, every president for life has a Bill of Rights, but the real key to the distinctiveness of America is the structure of our government. Our constitutional republic is also designed around the notion that the people, acting through their representatives, retain ultimate authority to govern. It was the people, through their representatives, who ratified the Constitution that establishes our system of government. Under that system, except where the Constitution has already answered the question, decisions are made by elected representatives. Elected, yes, but also accountable to the voters. But to endure, our system of self-government requires judges to apply the text of our laws as the people's representatives enacted them. So our judges, by design, play a crucial but limited role. They decide cases or controversies. But in resolving those cases, they may look only to the laws the people wrote. Judges are not free to rewrite statutes to get results they believe are more just. Judges are not free to reorder regulations to make them more fair. For sure, judges aren't free to update the Constitution. That's not their job. That power is retained by the people, acting through their elected representatives. And when our judges don't respect this limited power, when they substitute their own policy preferences for those in the legislative branch, they take from the American people the right to govern themselves. As that happens, inch by inch and step by step, representative government is undermined. The carefully constructed balance of power is upset, and individual liberty is lost. These aren't stale concepts. If anything, the enormous size, the enormous power, and the enormous complexity of the modern state renders them more relevant than ever before. In recent months, I've heard that now more than ever, we need a justice who is independent and who respects the separation of powers. Some of my colleagues seem to have rediscovered and appreciation for the need to confine each branch of government to its constitutional sphere. I don't question the sincerity of those concerns. Some of us have been alarmed by executive overreach and the threat it poses to separation of powers. Whether it was the executive branch unilaterally rewriting federal law, as the Obama administration did dozens of times, or the executive's repeated failure to enforce and defend the laws passed by Congress over the last 8 years, we've witnessed repeated abuses by one branch at the expense of the other two. Just ask the Supreme Court, which unanimously rejected arguments of the Obama administration made in more than 40 cases. The policies that drove those abuses were, of course, problematic, but policies can be changed and must be changed. To this senator, what's far more distressing about each executive overreach and each failure to defend the law is the damage that it does to the constitutional order. The damage those abuses inflict is far more difficult to undo than the policies that animated them. For, as John Adams observed, quote, liberty once lost is lost forever, end quote. So the separation of powers is just as critical today as it was during the administration, the last administration. And the preservation of our constitutional order, including the separation of powers, is just as crucial to our liberty today as it was when our founding charter was first adopted. No matter your politics, for all of these reasons, you should be concerned about the preservation of our constitutional order and, most importantly, the separation of powers. And if you're concerned about these things, as you should be, I want you to meet Judge Neal Gorsuch. Fortunately for every American, we have before us today a nominee whose body of professional work is defined by an unfailing commitment to these principles. His grasp on the separation of powers, including judicial independence, enlivens his body of work. As he explains, quote, to the founders, the legislative and judicial powers were distinct by nature, and their separation was among the most important liberty-protecting devices of the constitutional design, end of quote. About the executive, he writes that through, quote, the hard-won experiences under a tyrannical king, the founders found proof of the wisdom of government, of separated powers, end of quote. The judge's job, our nominee says, is to deliver on the promise that quote, all litigants, rich or poor, mighty or weak, will receive equal protection under the law and due process for their grievances, end of quote. The nominee before us understands that any judge worth the salt will, quote, regularly issue judgments with which they disagree as a matter of policy, all because they think that's what the law fairly demands, end of quote. Fundamentally, that is the difference between a legislator and a judge. All of us should keep this in mind during the course of this hearing. Judge, I'm afraid over the next couple of days, you'll get some questions that will cause you just to scratch your head. Truth be told, it should puzzle anyone who ever takes a civics class. We'll hear that when you rule for one party and against another in a case, it means you must be for the winner and against the loser. Senators will cite some opinions of yours, and then we'll hear that you're for the big guy and against the little guy. You will scratch your head when you hear this, because it's as if you judges write the laws instead of us senators. But if Congress passes a bad law as a judge, you're not allowed to just pretend that we pass a good law. The oath you take demands that you follow the law, even if you dislike the result. So if you hear that you're for some business or against some plaintiff, don't worry. We've heard all of that stuff before. It's an old claim from an even older playbook. You and I and the American people know whose responsibility it is to correct a law that produces a result that you dislike. It's the men and women sitting here with me. Good judges understand this. They know it isn't their job to fix the law. In a democracy, that right belongs to the people. It's for this reason that Justice Scalia said this, quote, "If you're going to be a good and faithful judge, you have to resign yourself to the fact that you're not always going to like the conclusion you reach. If you like them all the time, you're probably doing something wrong," end of quote. Judge, I look forward to hearing more about your exceptional record, and I look forward to the conversation we'll all have about the meaning of our Constitution and the job of a Supreme Court justice in our constitutional scheme. Senator Feinstein.
Thank you very much, Mr. Chairman. Judge Gorsuch, I want to welcome you and your family. We're here today under very unusual circumstances. It was almost a year ago today that President Obama nominated Chief Judge Merrick Garland for this seat. Unfortunately, due to unprecedented treatment, Judge Garland was denied a hearing, and this vacancy has been in place for well over a year. I just want to say I am deeply disappointed that it's under these circumstances that we begin our hearings. Merrick Garland was widely regarded as a mainstream, moderate nominee. However, President Trump repeatedly promised to appoint someone in the mold of Justice Scalia and said that the nomination of Judge Gorsuch illustrates he's a man of his word. For those of us on this side, our job is not to theoretically evaluate this or that legal doctrine or to review Judge Gorsuch's record in a vacuum. Our job is to determine whether Judge Gorsuch is a reasonable mainstream conservative or is he not. Our job is to assess how this nominee's decisions will impact the American people and whether he will protect the legal and constitutional rights of all Americans, not just the wealthy and the powerful. We hold these hearings not because court precedent and stare decisis are something average Americans worry about. We hold these hearings because the United States Supreme Court has the final word on hundreds of issues that impact our daily lives. The Supreme Court has the final say on whether a woman will continue to have control over her own body or whether decisions about her health care will be determined by politicians and the government. It decides whether billionaires and large corporations will be able to spend unlimited sums of money to buy elections, and whether states and localities will be able to pass laws and make it harder for poor people, people of color, seniors, and younger people to vote. It is the Supreme Court that will have final word on whether corporations will be able to pollute our air and water with impunity, or whether the NRA and other extreme organizations will be able to block common sense gun regulations, including those that keep military-style assault weapons off our streets. And it is the Supreme Court that will have the ultimate say on whether employers will be held accountable for discriminating against workers or failing to protect workers when they're harmed or killed on the job. For example, last year, Judge Gorsuch sat on a case that involved a truck driver who was stranded in the freezing cold for several hours after his trailer's brakes froze. He had no heat. In fact, it was so cold that the driver was having trouble breathing. His torso was numb and he could not feel his feet. Despite this, His employer directed him to wait for a repairman or else drive both the truck and the trailer. When no one came, the driver unhitched the trailer to search for assistance because driving with frozen brakes with a fully loaded trailer would have been too dangerous. A week later, he was fired. After hearing the case, the administrative law judge ruled that firing the driver was a violation of the health and safety law intended to protect workers. The United States Department of Labor's Administrative Review Board and the 10th Circuit agreed. Judge Gorsuch dissented and sided with the company. In another case, Judge Gorsuch wrote a separate opinion, this time to challenge a long-standing legal doctrine that allows agencies to write regulations necessary to effectively implement the laws that Congress passes and the President signs. It's called the Chevron Doctrine. This legal doctrine has been fundamental to how our government addresses real-world challenges in our country and has been in place for decades. If overturned, as Judge Gorsuch has advocated, legislating rules are very difficult. In fact, Congress relies on agency experts to write the specific rules, regulations, guidelines, and procedures necessary to carry out laws we enact. These are what ensure the Clean Air Act and the Clean Water Act to protect our environment from pollution. They are the specific protections put in place by the FDA and the Agricultural Department that safeguard the health and safety of our food supply, our water, our medicines, and they are the details needed to support the infrastructure of our communities, our roads, highways, bridges, dams, and airports. We in Congress rely on the scientists, biologists, economists, engineers, and other experts to help ensure our laws are effectively implemented. For example, even though Dodd-Frank was passed nearly 7 years ago to combat the rampant abuse that led to our country's worst financial crisis since the Great Depression, it still requires over 100 regulations to be implemented by the Securities and Exchange Commission, the Commodities Futures Trading Commission, and other regulators in order to reach its full effectiveness as intended by Congress when it was passed. Judge Gorsuch's position, were it to be adopted, would take away agencies' authorities to address these necessary details. Such a change in law would dramatically affect how laws passed by Congress can be properly carried out. 2 weeks ago, the Washington Post ran an op-ed written by a woman who desperately wanted to have a baby. She described how she and her husband went to great lengths for 4 years trying to get pregnant and were thrilled when they finally succeeded. Tragically, after her 21-week checkup, they discovered her daughter had multicystic dysplastic kidney disease. They were told by 3 separate doctors that her condition was 100% fatal and that the risk to the mother was 7-fold if she carried her pregnancy to term. The mother described their excruciating decision and the unforgiving process the couple endured to get the medical care they needed. The debate over Roe v. Wade and the right to privacy, ladies and gentlemen, is not theoretical. In 1973, the court recognized a woman's fundamental and constitutional right to privacy. That right guarantees her access to reproductive health care. In fact, the Supreme Court has repeatedly upheld Roe's core finding, making it settled law for the last 44 years. I ask unanimous consent, Mr. Chairman, to enter into the record the 14 key cases where the Supreme Court upheld Roe's core holding and the total 39 decisions where it has been reaffirmed by the court.
Without objection, it is included.
Thank you. If these judgments, when combined, do not constitute super precedent, I don't know what does. Importantly, the dozens of cases affirming Roe are not only about precedent, they are also about a woman's fundamental and constitutional rights. Roe ensured that women and their doctors will decide what's best for their care, not politicians. President Trump repeatedly promised that his judicial nominees would be pro-life and, quote, automatically, end quote, overturn Roe v. Wade. Judge Gorsuch has not had occasion to rule directly on a case involving Roe. However, his writings do raise questions. Specifically, he wrote that he believes there are no exceptions to the principle that, quote, the intentional taking of a human life by private persons is always wrong, end quote. This language has been interpreted by both pro-life and pro-choice organizations to mean he would overturn Roe. The Supreme Court is also expected to decide what kind of reasonable regulations states and localities can implement to protect our neighborhoods and schools from gun violence. In fact, just last month, the Fourth Circuit became the fifth appellate court to uphold a state's ban on assault weapons and large-capacity magazines under Heller. These new cases, taken together, enable the enactment of prudent and legal legislation to restrict military-style weapons from flooding our streets. Now, while George Gorsuch has not written decisions on the Second Amendment, he did write an opinion to advocate making it harder to convict a felon who illegally possessed a gun. In this opinion, Judge Gorsuch argued against the court's own precedent. Specifically, in this case, the defendant had been charged with attempted robbery in July of '09. After pleading guilty, he was given probation. However, quote, he was repeatedly, both orally and in writing, told that possession of a firearm, end quote, violated his probation, which would mean he could not, quote, escape the consequences of his felony conviction. Less than a year later, he was apprehended by the police holding, quote, a fully loaded high-point .380 caliber pistol with an obliterated serial number, end quote, in clear violation of his probation. Later, he argued he didn't know he was a felon. 6 circuit courts, including the 10th, have determined that the government does not need to prove a defendant knew he was a felon to convict for this crime. Despite this, Judge Gorsuch wrote 2 separate opinions that argued in favor of making it harder to convict felons who possess guns. In one, he wrote that sometimes following precedent, quote, requires us to make mistakes, end quote. I find this concerning. Following precedent in this case was not a mistake. It led to the conviction of a felon who should not have had a firearm. Judge Gorsuch has also stated that he believes judges should look to the original public meaning of the Constitution when they decide what a provision of the Constitution means. This is personal, but I find this originalist judicial philosophy to be really troubling. In essence, it means that judges and courts should evaluate our constitutional rights and privileges as they were understood in 1789. However, to do so would not only ignore the intent of the framers, that the Constitution would be a framework on which to build, but it severely limits the genius of what our Constitution upholds. I firmly believe The American Constitution is a living document intended to evolve as our country evolves. In 1789, the population of the United States was under 4 million. Today, we're 325 million and growing. At the time of our founding, African Americans were enslaved. It was not so long after women had been burned at the stake for witchcraft. And the idea of an automobile, let alone the internet, was unfathomable. In fact, if we were to dogmatically adhere to originalist interpretations, then we would still have segregated schools and bans on interracial marriage. Women wouldn't be entitled to equal protection under the law, and government discrimination against LGBT Americans would be permitted. So I am concerned when I hear that Judge Gorsuch is an originalist and a strict constructionist. Suffice it to say, and I conclude, the issues we are examining today are consequential. There is no appointment that is more pivotal to the court than this one. This has a real-world impact on all of us. Who sits on the Supreme Court should not simply evaluate legalistic theories and Latin phrases in isolation. They must understand the court's decision have real-world consequences for men, women, and children across our nation. Thank you, Mr. Chairman.
Senator Hatch for 10 minutes.
Well, thank you, Mr. Chairman. Judge Gorsuch, welcome back to the Judiciary Committee. This will be more of an ordeal than your last fitness for the appointment. It will be just as apparent. I've served on this committee for 40 years, and some things in the confirmation process never change. The conflict over judicial appointments is general, in general, and over this nomination in particular, is a conflict over the proper role of judges in our system of government. I've long believed that the Senate owes the President some deference with respect to his qualified nominees. Qualifications for judicial service include legal experience, which summarizes the past, and judicial philosophy, which describes the present and anticipates the future. Judge Gorsuch's legal experience is well known. My Democrat colleagues have referred to the American Bar Association's rating as the gold standard for evaluating judicial nominees. The ABA's unanimous, well-qualified rating for Judge Gorsuch confirms that he has the highest level of professional qualifications, including integrity, competence, and temperament. Judicial philosophy is both the more important qualification and the more challenging to assess. It refers to a nominee's understanding of the power and proper role of judges in our system of government. Over the last several weeks, I've addressed this issue on the Senate floor and in opinion pages around the country by contrasting what I have called impartial judges and political judges. An impartial judge focuses on the process of interpreting and applying the law according to objective rules. In this way, the law, rather than the judge, determines the outcome. A political judge, in contrast, focuses on a desired result and fashions a means of achieving it. In this way, the judge, rather than the law, often determines the outcome. In my experience, a Supreme Court confirmation process reveals the kind of judge that senators want to see appointed. A senator, for example, who wants to know which side a nominee will be on in future cases, or who demands that judges be advocate for certain political interests, clearly has a politicized judiciary in mind. The New York Times reported last week that the most prominent lines of attack against this nomination will be that Judge Gorsuch is, quote, no friend of the little guy, unquote. Something is seriously wrong when the confirmation process for a Supreme Court justice resembles an election campaign for political office. This dangerous approach contradicts the oath of judicial office prescribed by federal law. When taking the seat on the U.S. Court of Appeals in 2006, Judge Gorsuch swore to administer justice without respect to persons and to impartially discharge his judicial duties. His opponents today demand, in effect, that he violate that oath. Advocates of such a politicized judiciary seem to think that the confirmation process requires only a political agenda and a calculator. When a nominee is a sitting judge, they tally the winners and losers in his past cases and do the math. If they like the result, it's thumbs up on confirmation. If they don't, well, it's thumbs down. What if, for example, Judge Gorsuch's record on the appeals court was as follows? He voted against the plaintiff in 83% of immigration cases, against the defendant in 92% of criminal cases, denied race claims more than 80% of the time, and agreed with other Republican-appointed judges 95% of the time. I can just hear the cries of protest, accusations that he favors certain parties and is hostile to others, and threats of filibuster. That is, in fact, the record of a U.S. Circuit Court judge nominated to the Supreme Court, but not the one before us today. It is the record of Judge Sonia Sotomayor, as described by Senator Charles Schumer at her July 2009 confirmation hearing. Not only did he champion her nomination, but he offered that statistical summary of her record as proof that, as he put it, quote, she is in the mainstream, unquote. Oh, what a difference an election makes. Alexander Hamilton wrote about the importance of judicial independence, what Chief Justice William Rehnquist later called the crown jewel of our judicial system. Today, in a bizarre twist on that principle, Judge Gorsuch's opponents say that the only way for him to prove his independence is by promising to decide future cases according to certain litmus tests. In other words, judicial independence requires that he be beholden to them and their political agenda. If simply describing that unprincipled position is not enough to refute it, the confirmation process is in more trouble than I thought. Judge, I know that the integrity of the judiciary, fairness to the litigants who come before you, and your own oath of office are your highest priorities. You will be in good company by resisting efforts to make you compromise your impartiality. When President Lyndon Johnson nominated Judge Thurgood Marshall to the Supreme Court, Senator Ted Kennedy, my friend, who would later chair this committee, said, quote, we have to respect that any nominee to the Supreme Court would have to defer any comments on any matters which are before the court or very likely to appear before the court, unquote. Now, that was 50 years ago. When Justice Ruth Bader Ginsburg appeared before this committee in 1993, she said, quote, a judge sworn to decide impartially can offer no forecasts, no hints, for that would show not only disregard for the specifics of the particular case, it would display disdain for the entire judicial process, unquote. Now, in a speech earlier this year, Justice Sotomayor said this, quote, what you want is for us to tell you how, as a judicial nominee, we're going to rule on the important issues you find vexing. Any self-respecting judge who comes in with an agenda that would permit that judge to tell you how they will vote is the kind of person you don't want. You don't want as a judge. Now, I'll close by reading from a letter we received from dozens of Judge Gorsuch's Harvard Law School peers. After describing how they were of all political, ideological, religious, geographical, and social stripes, the signers wrote, quote, what unites us is that we attended law school with Judge Neal Gorsuch, a man we've known for more than a quarter century, and we unanimously believe that Neal possesses the exemplary character, outstanding intellect, steady temperament, humility, and open-mindedness to be an excellent addition to the United States Supreme Court, unquote. I agree with that appraisal by people from all walks of life, from different political views, people who agree with you and don't agree with you, but acknowledge that you're a great judge. And I look forward to this hearing, Mr. Chairman. Thank you.
Yeah, thank you, Senator. Senator from Vermont.
Oh, thank you, Mr. Chairman. I did find interesting the senator from Utah spoke about the Justice Sotomayor saying that these are the reasons in her nomination, the speech, these are the reasons why Republicans should vote for and Democrat vote against her. I would note, that, of course, that Senator Hatch voted against her. Today marks the first time the Senate Judiciary Committee has met publicly to take action on the Supreme Court vacancy that resulted from Justice Scalia's death 13 months ago. Because just hours after we learned of Justice Scalia's sudden passing, the Republican Majority Leader declared that the Senate would not provide any process to any nominee selected by President Obama, despite the president having nearly a year left in his term. This was an extraordinary blockade. It was totally unprecedented in our country's whole history. Some liken it to the action of the tyrannical kings who claim that they have sole control, as one of our senators referred to here a few minutes ago. But it was a blockade backed by then candidate Donald Trump. Committee Republicans met behind closed doors and declared that they would surrender the independence of this committee to do the majority leader's bidding, and they ignored the Constitution in the process. In fact, this unprecedented obstruction is one of the greatest stains on the 200-year history of this committee. Remember, the Judiciary Committee once stood against a court-packing scheme of a Democratic president that would have eroded judicial independence. And that was a proud moment. Now Republicans on this committee are guilty of their own court unpacking scheme. And the blockade of Chief Judge Merrick Garland was never grounded in principle or precedent. While Senate Republicans were meeting in back rooms to block President Obama's nominee, extreme special interest groups were also meeting in private to vet potential Supreme Court nominees for then candidate Donald Trump. I do not know of any other Supreme Court nominee who was selected by interest groups rather than by a president in consultation with the Senate as required by the Constitution. Now, Senate Republicans made a big show last year about respecting the voice of the American people in this process. Now, they're arguing that the Senate should rubber stamp a nominee selected by extreme interest groups and nominated by a president who lost a popular vote by nearly 3 million votes. And that president has demonstrated hostility to our constitutional rights and values. He's leveled personal attacks against federal judges and career prosecutors who dare to see his promised Muslim ban for what it is, unconstitutional. He called our constitutionally protected free press, quote, the enemy of the American people. When the president's chief of staff says the nominee before us has the vision of Donald Trump, well, that raises questions for people who have actually read the Constitution or cares about the rights it protects. More than perhaps any confirmation hearing for the last 30 years, I expect this nominee's judicial philosophy will play a central role. Now, Judge Gorsuch has spent more than a decade on the federal bench. He graduated from Harvard Law School. He clerked for the Supreme Court. He served in the Department of Justice. He received a unanimous, well-qualified rating from the American Bar Association. All things very positive for a Supreme Court nominee. And if all those things I've read were sufficient reason to confirm a nominee to the Supreme Court, well, of course, Chief Judge Merrick Garland, who had exactly the same qualifications, but was refused by the Republicans, would be sitting on the court today. That's why philosophy becomes important. In contrast to past nominees like John Roberts, whose judicial philosophy was not clearly articulated when he appeared before this committee, Judge Gorsuch appears to have a comprehensive originalist philosophy. It's the approach taken by jurists such as Justice Scalia, Justice Thomas, former Judge Bork. What has gained some popularity within conservative circles, originalism, I believe, remains outside the mainstream of modern constitutional jurisprudence. It's been 25 years since an originalist has been nominated to the Supreme Court. Given what we've seen from Justice Scalia and Justice Thomas and Judge Gorsuch's own record, I worry that it goes beyond being a philosophy and it becomes an agenda. We know that conservative groups that vetted Judge Gorsuch and the millionaires who fund them have a clear agenda. One that's anti-choice, anti-environment, pro-corporate. And these groups are obviously confident that Judge Gorsuch shares their agenda. The first person to interview Judge Gorsuch in this process explained these groups did not ask who's a really smart lawyer who's been really accomplished. Instead, they saw a nominee who understands these things like we do. After all, Judge Gorsuch has been described by a former leader of the Republican Party as a true loyalist and a good, strong conservative. Now, the concerns I have about Judge Gorsuch's judicial philosophy and the process by which he is selected, the views of the president nominated, I hope and expect, Judge, that you will answer my questions and the questions of all the senators, both parties, as clearly as possible. You know, it's not enough to say in private that the president's attacks on the judiciary are disheartening. I need to know that you understand the role of the courts in protecting the rights of all Americans. I need to know that you can be an independent check and balance on the administration that's nominated at you and on any administration that might follow it. Judge Gorsuch, these hearings occurring the week after Sunshine Week are the first opportunity for the American people to hear your views on the role of the courts, the meaning of our Constitution. Like the founders who did not know what legal questions would be presented in the decades to come, they set this constitutional process. It's important to determine whether you understand how the court has a profound impact on small businesses and workers, on law enforcement and victims, on families and children across America. It is not contrary to the duties and obligations of a Supreme Court justice to consider the effects of their rulings. The court's aspiration, after all, is to provide equal justice under law. That's inscribed in Vermont marble over the doorway to the court. Judge Gorsuch, these hearings will help us conclude if you're committed to the fundamental rights of all Americans. Will you allow the government to intrude on Americans' personal privacy and freedom? Will you elevate the rights of corporations over those of real people? And will you rubber stamp a president whose administration has asserted that executive power is not subject to judicial review? It's important to know whether you serve with independence or as a surrogate to the president who nominated you, or the special interest groups that provided that president with your name. Now, I approach these hearings with these thoughts in mind. I can honestly say I have yet to decide how I'm going to vote in this nomination. Unlike those who blocked the nomination of Chief Judge Merrick Garland, I believe it's my constitutional responsibility to fairly evaluate a president's nominee to the Supreme Court. I voted for Supreme Court nominees. I voted against others. I recall going on the floor of the Senate right after our Democratic leader said he would vote against John Roberts for Chief Justice. I was the next speech. I said I would vote for him. But I'm going to base my determination on the full record at the conclusion of these hearings, just as I've done for the 16 previous Supreme Court nominees since I've been in the Senate. The Supreme Court is a guarantor of the liberties of all Americans. Judge Gorsuch, when you took the oath to sit on the federal bench, you spoke these following words that are in a judicial oath. I will administer justice without respect to persons and do equal right to the poor and to the rich. If confirmed, you have to be a justice for all Americans, not for the special interests of a few. You know, I can't think of any time in our nation's history when that commitment is more important than it is now. That's what I've been thinking of all weekend long. The stakes for the American people could not be higher. We know that in Vermont, but America knows that. I thank you, Mr. Chairman.
Yeah, and thank you, Senator Leahy. Now to Senator Cornett.
Thank you, Mr. Chairman. Judge Gorsuch, welcome to you and your family. As you can already tell, this is going to be a much different experience than you had 10 years ago when you were confirmed by voice vote of the entire United States Senate to the 10th Circuit Court of Appeals to a life tenured position. The Senate Judiciary Committee undertakes no task more important than the one before us, considering a nominee to the United States Supreme Court. As you know, historically, these used to be pretty routine, but that's until judges became seen as policymakers rather than as impartial interpreters and appliers of the law. The nation is watching, and I think that's a really good thing. At a time when fewer and fewer American citizens know our founding story and the principles upon which it is based, I think this is a wonderful opportunity for a teachable moment. And I would encourage you to take every opportunity to engage in that. We're considering a nominee, of course, left by the death of Justice Antonin Scalia. And as we've heard before, Justice Scalia was unique. His wit and style brought the Constitution to life for lawyers in their first year of law school and for the American public at large. He led the most important legal revolution in our lifetimes, tethering judicial interpretation to the written text. What a concept. This is part of the broader project, which the nominee before us, Judge Neal Gorsuch, described as, quote, reminding us of the differences between judges and legislators, that judges should strive to apply the law as it is, not to decide cases based on their own moral convictions or the policy consequences they feel might serve society best. In one dissent, Justice Scalia wrote along similar lines that, quote, if our pronouncements of constitutional law rely primarily on value judgments, then a free and intelligent people's attitude toward us can be expected to be quite different. The people know that their value judgments are quite as good as those taught in any law school, and perhaps better. The framers, I believe, shared Justice Scalia's and your modest view of the role of judging. Alexander Hamilton wrote, for example, the judiciary may truly be said to have neither force nor will, but merely judgment. After Justice Scalia's death, Senate Republicans decided to let the American people in this last presidential election choose his successor. In Judge Gorsuch, President Trump chose one of the most accomplished lawyers and jurists of his generation. As we've heard, he's a husband and a father of 2 daughters, lives in his native Colorado, and if confirmed would be our only Western justice. Justice Gorsuch attended Columbia and Harvard Law School and, of course, got his doctorate at Oxford. After clerking for 2 Supreme Court justices, Byron White and Anthony Kennedy, he went to work for a startup law firm that grew to be one of the nation's most prestigious, where he spent a decade, as he put it, working in the trenches of the law. As a recovering lawyer and judge myself, I think it's critically important. Judge, it means that you understand better than most the impact of your decisions, actually having represented real live clients. The law is not just an academic or intellectual exercise. It has real consequences for real people. And I'd encourage you to talk about those real people that you came in contact with during your legal and judicial career. After serving his country at the Justice Department, Judge Gorsuch, as I mentioned earlier, was nominated and confirmed to the 10th Circuit. Not one of our Democratic colleagues then in the Senate opposed Neal Gorsuch for the 10th Circuit Court of Appeals because there was simply no reason to do so. In the decades since, Judge Gorsuch has written hundreds of opinions on the Constitution and innumerable laws. He's demonstrated that he actually reads the text carefully to get the right result. I'm reminded that there is a difference between what we sometimes loosely call a strict constructionist and a textualist, and I'd invite you to make that point during some of your testimony. As you can see here today, his jurisprudence reflects brilliance and humility, the humility of a man committed to the Constitution and the law. That body of work is the best guide for the kind of judge Judge Gorsuch will be. Answers to questions posed during these hearings, we've already heard about specific issues, cannot and should not be a guide. You're not a politician running for election, Judge, as you know. In the dissent I mentioned earlier, Justice Scalia warned that, quote, confirmation hearings for new justices should deteriorate into question and answer sessions in which senators go through a list of their constituents' most favored and most disfavored alleged constitutional rights. It should not be the forum in which you seek the nominee's commitment to support or oppose them. So we're not here to ask you, even though some might, how you will vote in specific cases. And it'd be wrong for you to prejudge those cases, as you know. And that's the same reason why, for example, Ruth Bader Ginsburg, during her nomination hearing, said a judge sworn to decide impartially can offer no forecasts, no hints, for that would not only show disregard for the specifics of a particular case, it would display disdain for the entire judicial process. Can you imagine what a litigant might think if the judge before whom he or she was to present their case said before they heard a word how they were going to decide the case? That's why it's improper for you, as you know, to prejudge cases in your testimony before the committee. And our colleagues know that as well, but I expect them to ask a few questions nonetheless. Well, lately we've heard from some that they should criticize you for failing to rule for a sympathetic constituency in one case or another. But of course, as you know, Judge, if you follow the law and the facts wherever it may lead, sometimes it's for the police, sometimes for a criminal defendant, sometimes it's for a corporation, sometimes it's for an employee, sometimes it's for the government, sometimes it's against the government. That's how the rule of law works, and that's good for all Americans. One law professor at Harvard wrote, following the law, regardless of the parties, is in the long run, it protects the little guy a lot better than a system rigged to favor one side. Because of your qualifications and a demonstrated record of following the law, other than a few special interest groups, I believe you've got a broad spectrum, really surprisingly broad spectrum of people supporting your nomination. One of your colleagues on the left wrote in Washington Post, the Senate should conform Judge Gorsuch because there's no principled reason to vote no. Another liberal constitutional scholar joined a letter that stated, Judge Gorsuch has the unusual combination of character, dedication, and intellect that will make him an asset on our nation's highest court. President Obama's Solicitor General, from whom this committee will hear, wrote in the New York Times that liberals should back Judge Gorsuch because he would live up to the promises to administer justice with respect to persons and to do equal right to the poor and to the rich. So, Mr. Chairman, the list goes on and on. So I'm very pleased the American people are about to learn why President Trump chose you as his nominee for the Supreme Court. I look forward to hearing from Judge Gorsuch, and I would encourage my colleagues to carefully consider the nominee on the merits and nothing else.
Thank you, Senator Cornyn. Now, Senator Durbin.
Thanks, Mr. Chairman. Judge Gorsuch, welcome to you and your family. I've often read stories about earlier Supreme Court nominees and how little politics played any role in the selection and vetting of the nominees. Those of us on the Democratic side, as you can hear, are frequently warned not to let politics to be part of this decision. When I consider the path to this historic hearing, this plea rings hollow. The journey began with the untimely death of Justice Scalia in February of 2016. President Obama met his constitutionally required obligation by nominating Judge Merrick Garland to fill that vacancy in March of 2016. Senate Republican leader Mitch McConnell announced that for the first time in the history of the United States Senate, he would refuse Judge Garland a hearing and a vote. He went further and said he would refuse to even meet with the judge. It was clear that Senator McConnell was making a political decision, hoping a Republican president would be elected. He was willing to ignore the tradition and precedent of the Senate so that you could sit at this witness table today. In May and September of 2016, Republican presidential candidate Donald Trump released a list of 21 names, including yours, that he would consider to fill the Scalia vacancy. President Trump thanked the Federalist Society and the Heritage Foundation, two well-known Republican advocacy groups, for providing the list that included your name. Your nomination is part of a Republican strategy to capture our judicial branch of government. That is why the Senate Republicans kept this Supreme Court seat vacant for more than a year, and why they left 30 judicial nominees who had received bipartisan approval of this committee to die on the Senate calendar as President Obama left office. Despite all of this, you're entitled to be judged on the merits. The Democrats of the Senate Judiciary Committee will extend to you a courtesy which Senate Republicans denied to Judge Garland: a respectful hearing and a vote. Judge Gorsuch, you've been nominated to a lifetime appointment on the highest court in the land, and this court has the final say on matters of fundamental importance affecting all Americans. You have a lengthy record before the 10th Circuit and will ask many questions. We have found in the past that nominees try their best to dodge most of the questions, but it's our job to try to still seek the truth. At the nomination hearing of Justice Ruth Bader Ginsburg, my friend and predecessor, Senator Paul Simon, set forth a standard for Supreme Court nominees. I've noted this with each Supreme Court nominee that I've questioned. He said, quote, "You face a much harsher judge than this committee, and that's the judgment of history. And that judgment is likely to revolve around the question, did you restrict freedom or did you expand it?" Let me be clear, when I talk about expanding freedom, I'm not talking about freedom for corporations. We the people does not include corporations. Senator Simon could never have imagined that the Supreme Court would give corporations rights and freedoms that were previously reserved only for individuals under the Constitution. And yet that's where we find ourselves with the Roberts Court. It's often said the Roberts Court is a corporate court because of its pro-business tilt. A study by the Constitutional Accountability Center found that the court ruled for the U.S. Chamber of Commerce 69% of the time. The court has certainly favored big business on issues like forced arbitration, corporate price fixing, workplace discrimination cases, just to name a few. But the Roberts Court has gone further than just ruling the way corporate America wants. In the 2010 Citizens United case, the Supreme Court held for the first time that corporations have the same rights as living, breathing people to spend money on elections. And that was followed in 2014 by the Hobby Lobby decision, which allowed for-profit corporations to discriminate against employees based on the corporation's assertion of religious belief. I don't recall ever seeing a corporation in the pews of Old St. Patrick's Church in Chicago. Our founders never believed that corporations were endowed with certain inalienable rights, but we're seeing the Supreme Court expand the rights of this legal fiction, a corporation, at the expense of the voices and choices of the American people. This strikes at the heart of the Supreme Court's promise to provide equal justice under the law. Judge Gorsuch, you took part in that Hobby Lobby case when it was before the 10th Circuit. As I read the case, I was struck by the extraordinary, even painful lengths the court went to protect the religious beliefs of the corporation and its wealthy owners, and how little attention was paid to the employees, to their constitutionally protected religious beliefs, their choices as individuals, and the burdens that the court's decision placed on them. I want to hear from you about a pattern I've seen in your decisions on the 10th Circuit. In case after case, you've either dismissed or rejected efforts by workers and families to recognize their rights or defend their freedoms. Cases like Trans Am Trucking, which we've already spoken to. Alphonse Madden. Had a chance to sit down with him just last week. He was the truck driver from Detroit who was driving around Chicago in the middle of January when a malfunction in his trailer froze the brakes and he was forced to pull over on the side of the road. Al sat there on his cell phone with the dispatcher for the truck company who told him, don't leave this truck no matter what, and if you do, pull the trailer with you. Well, that was a big problem because the brakes were frozen and it would have been a safety hazard. And so he waited and waited, and the hours passed, and he started feeling numb and sick. You see, there was no heater in the truck, and according to his recollection, it was so cold, it was 14 degrees below. Not as cold as your dissent, Judge Gorsuch, which argued that his firing was lawful. You cited a strict textualistic argument to make your point, but you chose the text that you focused on. Thank goodness the majority in this case pointed out that common sense in the Oxford Dictionary supported the majority view. Compass Environmental Incorporated, another one of your cases, your dissent would have vacated a penalty against an employer who failed to train construction employee Christopher Carter to avoid the electrocution hazard that killed him. Strickland versus UPS, your dissent would have kept Carol Strickland's sex discrimination case from going to a jury, even though your fellow judges said she provided ample evidence that she was regularly outperforming her male colleagues and treated less favorably. I want to hear more about your views on fundamental individual rights that the Supreme Court is tasked to defend: the right to privacy, the right for all faiths to practice their religion, the right to vote, equal protection, and the rights of women. The committee has received 2 letters from students who you taught last year that raise some serious concerns. Tomorrow we'll get to the bottom of it, I hope. We've learned you were an aggressive defender of executive power during the time of the Bush administration. In June 2004, after the Abu Ghraib torture scandal, I authored the first bill to ban cruel, inhuman, and degrading treatment of detainees. That legislation became the McCain Torture Amendment, which passed the Senate in December of 2005 by an overwhelming 90-9 vote. But when President Bush signed the amendment into law, he issued a signing statement claiming he had the authority to ignore the McCain Amendment. Turns out you were deeply involved in this unprecedented signing statement. We need to know what you'll do when you're called upon to stand up to this president or any president if he claims the power to ignore laws that protect fundamental human rights. You're going to have your hands full with this president. He's going to keep you busy. It's incumbent on any nominee to demonstrate that he or she will serve as an independent check or balance on the presidency. There are some warning flags. February 23rd, White House Chief of Staff Reince Priebus said, and I quote, "Neal Gorsuch represents the type of judge that has the vision of Donald Trump," close quote. I want to hear from you why Mr. Priebus would say that. Make no mistake, when it comes to the treatment of workers, women, victims of discrimination, people of minority religious faith, and our Constitution, most Americans question whether we need a Supreme Court justice with the vision of Donald Trump. With my constitutional responsibility firmly in mind, I look forward to questioning tomorrow. Thank you, Mr. Chairman.
Thank you, Senator Durbin. Now, Senator from Utah.
Thank you, Mr. Chairman, and thank you, Judge Gorsuch, and welcome to the committee. I also want to welcome your friends, family members, supporters, former colleagues, and people you've worked with over the years who have come to show their support. I know they're proud of you, and they're proud of you not just because of what you've done, what you've accomplished professionally, but also because of who you are personally, a man of integrity, a man of great accomplishment, a man of character, and a man of faith. Everyone knows that a Supreme Court confirmation hearing can be dramatic, even emotional at times. The stakes are high. As senators, we understand that there are a few things that are more important than the obligation that we're performing here, than the duty that we're carrying out in connection with this process. These days, it seems like standing for a confirmation hearing in the United States Senate after being nominated to the Supreme Court of the United States can appear a little bit like running for political office. As we've seen over the last few weeks, there are interest groups out there, some supporting you, some opposing you, out there waging campaigns almost as if they were running a campaign for someone pursuing public office. Maybe that's why, especially on this side of the dais, it can be easy to forget that a nominee is an ordinary citizen. Perhaps not ordinary in the usual sense, but at least that person is not a politician. You, sir, are not a politician, which means that the acrimony, the duplicity, the ruthlessness of today's politics are still a little foreign to you, are still quite unfamiliar to you. I hope that they will remain unfamiliar to you. In a former life, when I was a practicing attorney, I had the good fortune of appearing in front of you on the 10th Circuit. And so I know from my own personal experience that you're one of the best judges in the country. You come to oral argument prepared, and you ask fair, probing questions that are designed to get at one thing and one thing only, which is what the law says and what the law requires in each individual case, depending on the facts and circumstances of that case. You weren't there to promote a personal agenda or a political agenda, and you're not there to grandstand. You're there to listen to both sides of the argument in the case. You write thoughtful and rigorous opinions. They're careful and they're well-reasoned, and they're even interesting and pleasant to read, which is very difficult to achieve in the world of appellate litigation. Now, I know I'm easily entertained, but I find your opinions particularly interesting. You have the resume of a Supreme Court justice, but I think what's most impressive, and for our purposes what's most important about your career and about the approach you take to the law, is your fierce independence from partisan influence and from any personal biases that you might otherwise be inclined to harbor. The judiciary is set apart from, and in a way set far above, the other branches in our republic, the other organs of our constitutional system, specifically because we allow it to invalidate and interpret the actions of the elected branches. So we've got two branches of government that are political in that they're run by people who are elected and stand for re-election at regular intervals, thus making themselves directly accountable to the American people. Our confidence in our entire system, including our confidence in the American judiciary, depends entirely on judges just like you, judges who are independent and whose only agenda is getting the law right, regardless of whether any particular judge or any particular litigant or any particular member of the public might like or dislike the outcome in that case. You are essential to making us accountable, because unless you do your job right, we aren't held accountable because our laws don't stand. That's what makes your role and your particular unique approach and your particular unique commitment to this so important. Now, I want to take a moment to address some of the unique criticisms that you yourself, Judge Gorsuch, might be facing this week. I'm sure that during this hearing, some of my colleagues might claim that you're outside the mainstream. In fact, we've sadly heard some of that already today. We've heard arguments to the effect that you were an originalist, and we've heard assertions to the effect that originalism is somehow so far out of the mainstream that it's dangerous. Well, I remind my colleagues who have raised such concerns or who might be harboring them that if this is the case, then they're going to have to acknowledge the fact that there's a pretty broad spectrum of people on the United States Supreme Court who they might be painting with that brush. Justice Elena Kagan, before she was Justice Kagan, when she was standing before this committee in the second day of her confirmation hearings, said, and I quote, referring to the Founding Fathers and the need to figure out what the Founding Fathers understood about particular words, about how those particular words were used by the founding generation, said sometimes they laid down very specific rules, sometimes they laid down broad principles. Either way, we apply what they tried to do. In that way, we are all originalists. That was on June 29th, 2010, before this committee. Moreover, these out of the mainstream arguments, this out of the mainstream approach for addressing you, referring to you as an originalist just doesn't stick. This is not a description that was attributed to you the last time you stood before this committee and went through a confirmation process. Nowhere in the record is there any reference to you being outside the mainstream. In fact, your nomination to the United States Court of Appeals for the 10th Circuit was so remarkably uncontroversial that one senator, and only one senator, Senator Lindsey Graham from South Carolina, was the only member of this committee who even bothered to show up at your confirmation hearing. Now, I would have been there too, Judge. I was not yet a member of the United States Senate. You were confirmed unanimously by voice vote without a single no vote. I'm sure that some of my colleagues will question your independence because in their view, perhaps you haven't sufficiently criticized the comments made by some of today's politicians. Personally, I think you've made your views on this subject very clear. I'm sure some of my colleagues will complain that you aren't providing any hints as to how you might rule in any particular case. But that, however, is a reason for your confirmation, certainly not against it. In our system, judges don't provide advisory opinions. They don't make legislation. They don't legislate. They don't make law. They don't set policy in the same sense that those things are made in the political branches. They decide cases and controversies only after each side has had the opportunity to make its case before the bench, and they do so outside the realm of political influence. In an odd twist, some of the same colleagues who will question your independence will also push you to answer questions that you simply can't. I'm sure that some of my colleagues will pick apart some of your rulings. They'll try to say that you're hostile to particular types of claims or to particular plaintiffs. I don't think it's productive to evaluate someone's judicial record by looking at who wins or who loses in his courtroom, at least outside the context of evaluating how the law was interpreted in that case. It goes without saying that in our system, you face the same burden of convincing a court, regardless of who you are. And judges don't decide cases. They certainly should never decide cases based on their own personal preferences. But to my colleagues who go down that road, the record shows with abundant clarity that you apply the law neutrally in all cases, without regard to the parties. Finally, I'd urge my colleagues to keep in mind that while Judge Gorsuch's reputation won't be affected by how we treat his confirmation, the same can't always be said of the Senate. The night Judge Gorsuch was nominated, he said the U.S. Senate is the greatest deliberative body in the world. I tend to agree, but these days it seems like this title is more of a challenge than an observation. It's more of an aspiration than a present sense description of reality. So I hope we prove you right this week. Thank you very much, and I really look forward to hearing answers to the questions we'll raise to you.
Thank you, Senator Lee. Now, Senator Whitehouse.
Judge Gorsuch, welcome. As we discussed when we met, the question that faces me is, what happens when the Republicans get 5 appointees on the Supreme Court? I can't help but notice the long array of 5-4 decisions with all the Republican appointees lining up to change the law to the benefit of distinct interests, Republicans at the polls and big business pretty much everywhere. Let's look at the 5-4 decisions. First, helping Republicans at the polls. All the Republican appointees' 5-4 decisions on election law favor Republicans at the polls, 6-0. Helping Republicans gerrymander, paving the way for the Republican red map plan that won the House against the American majority in 2012. Jubileer, 5-4, all the Republican appointees. Helping Republican legislatures keep Democrat-leaning minorities away from the polls with targeted voter suppression laws. Shelby County, 5-4, all the Republicans. Bartlett v. Strickland, 5-4, all the Republicans. Helping corporate money flood elections and boost Republican candidates. McCutcheon, 5-4, all the Republicans, counting the concurrence. Bullock, 5-4, all the Republicans. And the infamous Citizens United decision, 5-4, all the Republicans. In each area, the court made new law, 5-4, and each decision predictably helped Republicans win elections. At 6-0, it's a partisan rout. Then look at cases that pit corporations against human beings. All the 5-4 Republican appointee decisions line up to help corporations against humans. Citizens United and the political money decisions should again count here. All three of them 5-4, all the Republicans. Then come decisions that protect corporations who've harmed their employees. In pay discrimination, Ledbetter, 5-4, all the Republicans. In age discrimination, Gross, 5-4, all the Republicans. In harassment cases, Vance, 5-4, all the Republicans. In anti-retaliation cases, Nassar, yep, you guessed it, 5-4, all Republicans. Then there are the decisions that protect corporations from class action lawsuits. Walmart v. Dukes, 5-4, and Comcast, 5-4, both all Republicans. Then there are decisions that help corporations steer customers away from juries and into corporate-friendly mandatory arbitration. Concepcion and Italian Colors Restaurant, both 5-4, both all Republicans. The Iqbal decision, 5-4, all Republicans, helped bar the courthouse door for all types of plaintiffs. All of this helps keep corporations away from juries, the one element of government hardest for corporations to control. Indeed, as you know, tampering with a jury is a crime. The court also helps big business against unions. Harris v. Quinn, 5-4, all Republicans. Last year, Friedrichs was teed up as a 5-4 body blow against unions when Justice Scalia died. With a new 5-4 court, they'll be back. Throw in Hobby Lobby. Corporations have religious rights that supersede health care for their employees. 5-4, all Republicans. Add Heller and McDonald, reanimating for gun manufacturers a legal theory a former Chief Justice once called a fraud. 5-4, all Republicans. Help insulate investment bankers from fraud claims? Why not? Janus Capital Group, 5-4, all Republicans. Chamber of Commerce v. EPA gave corporate polluters an unprecedented victory. Again, 5-4, all Republicans. That's an easy 16-0 record for corporations against humans. To me, every time seems like a lot. There's no coincidence here. Big business has law groups out trolling for test cases to go get those cases before the friendly court. The Republican politico-industrial complex piles in with amicus briefs and floods to tell the Republican appointees on the court what it wants. Republican justices are even starting to give hints so big business lawyers can rush to get certain cases up pronto to the court. It's kind of a machine. Special interests set up and fund front groups. The front groups appear as amici before the court. The amicus briefs of the front groups tell the court what the special interests want. The court follows the amicus briefs. The decision benefits the special interests, and the special interests pour more money to the front groups. On it goes like turning a crank. The biggest corporate lobby of them all is winning better than 2-1 at the court. This 5-4 rampage is not driven by principle. Over and over, judicial principles, even so-called conservative ones, are overrun on the court's road to the happy result. Stare decisis. That's a big laugh. These were law-changing decisions, many upending a century or more of law and precedent. Textualism. The Second Amendment uses the military term, arms, and talks about militias, but never mind that when the gun lobby wants something. Originalism. There's a particularly good one. Find me a founding father who planned a big role for business corporations in American elections, or one who would have countenanced the steady strangulation of the civil jury without so much as a mention of the Seventh Amendment. The Citizens United majority even fiddled with court procedure to get to the decision it wanted to deliver, dodging its way around a record that would have belied their findings of fact, setting aside that their findings of fact were factually preposterous, as events have shown, and that appellate courts are not even supposed to make findings of fact. It's not just us who notice. Top writers and scholars describe the Roberts Court as essentially a delivery service. Jeffrey Toobin wrote in 2009, even more than Scalia, Chief Justice Roberts has served the interests and reflected the values of the contemporary Republican Party. Linda Greenhouse in 2014, I'm finding it impossible to avoid the conclusion that the Republican-appointed majority is committed to harnessing the Supreme Court to an ideological agenda. Norm Ornstein has described what he called the new reality of today's Supreme Court. It is polarized along partisan lines in a way that parallels other political institutions and the rest of society in a fashion we have never seen. Studies of the court's decisions show it's the most corporate-friendly court in modern history, with Justices Roberts and Alito vying to be the most corporate-friendly justice. And the American public knows something's gone wrong at the court. A 2014 poll revealed that a majority of Americans think a person won't get a fair shake in this court against a corporation. Now, where do you fit in? When Hobby Lobby was in the 10th Circuit, you held for a corporation having religious rights over its employees' health care. Your record on corporate versus human litigants comes in by one count at 21-2 for corporations. Tellingly, big special interests and their front groups are spending millions of dollars in a dark money campaign to push your confirmation. We have a predicament. In ordinary circumstances, you should enjoy the benefit of the doubt based on your qualifications. But several things have gone wrong that shift the benefit of the doubt. One, Justice Roberts sat in that very seat, told us he'd just call balls and strikes, and then led his 5-person Republican majority on that activist 5-4 political shopping spree. Once burned, twice shy. Confirmation etiquette has been unhinged from the truth. 2, Republican senators denied any semblance of due legislative process to our last nominee, one, I would say, even more qualified than you, and that's saying something. Why go through the unprecedented political trouble to deny so qualified a judge even a hearing if you don't expect something more amenable to come down the pike? Those political expectations also color the benefit of the doubt. Finally, the special interests who've done so well in that 5-4 extravaganza of decisions are now spending millions and millions of dollars campaigning to push your nomination. They obviously think you will be worth their money. These special interests also supported the Republican majority keeping this seat open. I'm afraid that all costs whoever now sits in that seat the benefit of the doubt to answer this question: will you saddle up with the other Republican appointees and launch the court 5-4 again on another massive special interest and Republican election spree? I hope, whatever we may disagree about on this committee, we can at least agree that we can't have a court where litigants in these 5-4 decisions can predict how they'll do based on who they are. Because here's what it looks like now. If they're big Republican election interests, they'll win every time. If they're corporations against a human being, they will win every time. And, Your Honor, every time seems like a lot. Thank you, Chairman.
B. Graham.
Thank you, Mr. Chairman. There's a reason I did not do this litany with Democratic nominees that appeared before the committee. I don't think it would have made any difference in terms of how other people voted, and I didn't expect them to vote with the Republican majority, Elena Kagan and Sonia Sotomayor. I could have spent a lot of time talking about how antagonistic they are to the Second Amendment, in my view, how the unborn doesn't have much of a chance in their court, how the environmentalists always win, and there's no government too big to be said no to. The reason I didn't do that is because I thought they were qualified. And if you believe this has been a great plan to get a Trump nominee on the court, then you had to believe Trump was going to win to begin with. I didn't believe that. Obviously, I didn't believe that, saying all the things I said, followed closely by Ben. But apparently, what I said didn't matter, and that's okay with me. The American people chose Donald Trump, and here's what I can say about the man in front of us. No matter who had won our primary, no one could have chosen better than Neal Gorsuch to represent conservatism on the Supreme Court. So Donald Trump deserves to be congratulated for listening to a lot of people and coming up with, I think, the best choice available to a Republican president in terms of nominating somebody who is going to keep the conservative philosophy alive and well in the court. And I doubt if you'll be disappointed many times with Judge Gorsuch, but he's a pretty independent guy from what I can tell. You'll probably be more disappointed. I've never been disappointed with Sotomayor and Kagan in the sense I knew what I was getting. They always vote with the liberal bloc. They're very qualified people. Sometimes the court comes together 9-0 to reject something. But most of the time, people break along the lines of where they came from. And I think Sotomayor and Kagan came from a view of the law that I don't accept in terms of who I would have chosen, but was well within the mainstream of judicial philosophy from the left. I thought they led exemplary lives, quite frankly. There were a lot of attacks on them that I didn't echo because I thought, give me a break. Really, are these the two worst women in the world? They lived exemplary lives, were highly qualified, and that's why I voted for them. I thought that's what we should be doing, and I'm beginning to wonder now how the game is played. I do remember when I voted for them, how many good editorials I got from papers that nobody in South Carolina read. I miss Harry. Harry's around here somewhere, Harry Reid. He said something nice about me. I can't find it. But he basically said that I wished more people would follow Senator Graham's lead when it comes to voting for very highly qualified nominees. He said that on the floor. Maybe that'll happen in the future. Well, time will tell. Now, as to whether or not this man is highly qualified, I'm dying to hear the argument that he's not. You may not like the view he has of the law, but I'm dying to hear somebody over there tell me why he's not qualified to be sitting here when a Republican president occupies down the street. Now, when you look at the Federalist Papers, I saw the musical Hamilton. It was pretty good. Reading his work was even better. And in the Federalist Papers 78, 87, I can't remember the number, basically what he tells us is that the role of the Senate is to make sure that the president doesn't pick someone specially favored for their state, an association to their family, someone really cronyism, I guess, is what we're supposed to be doing. And most Supreme Court justices, up until modern times, basically were confirmed with a voice vote. So things have changed, and we can't lay all the blame on our Democratic friends about politicizing the selection process. What I want to say to the public is I'm glad people like Judge Gorsuch are willing to go through this. And I'm sure Justice Sotomayor and Kagan had wished on a couple of days they had not chosen that path, but I think they made it through, quite frankly, with flying colors. So the issue for me is I'm waiting to hear somebody over there tell me why you're not qualified for the job that you're seeking. 2,700 decisions, and you've been overruled once. An academic record. The reason I didn't do all the things you did academically, I couldn't get into the schools you were able to get into. But the way you've handled yourself, I think you should be proud of the way you've handled yourself on the court. I think all the statements by your colleagues who know you better than anybody up here, when no TV cameras rolling, say nothing but great things about you, even people who have a different philosophy. So I just want you to know that from my point of view, you're every bit as qualified as Justice Sotomayor and Kagan. I think you're just as good a man as they are two fine women. And over the course of the next couple of days, the American people are going to get to understand who you are and within limits your judicial philosophy. They're going to want you to decide every case they don't like here, and you'll have to say no. And there's a reason I didn't ask Justice Sotomayor and Kagan to give me an opinion as to what they would do when they got on the court, because I knew they wouldn't tell me that. Didn't really feel comfortable asking them that. As to Justice Garland, the one thing I can say for sure is that when Justice Scalia passed on February the 13th, we'd already had 3 primaries on the Republican side, and the campaign was in full swing on the Democratic side. I thought long and hard about that. Are we doing something unfair here by not allowing the current president to nominate somebody and fill a vacancy in the last year of their presidency after the political process had started? So when I started looking around at what other people thought, here's what Joe Biden thought in '92. If someone steps down, I'd highly recommend the president not name someone and not send up a name up. If Bush did send someone up, I would ask the Senate seriously consider not having a hearing on that nominee. It would be a pragmatic conclusion that once the political season is underway, and it is, action on Supreme Court nominations must be put off until after the election campaign is over. That's what my friend Joe said in 1992. The bottom line here is I have no doubt in my mind if the shoe were on the other foot, the other side would have delayed the confirmation process until the next president were elected. In 100 years, when we've had the president of one party in power and the Senate in the hands of another party, I think we have one person confirmed in the last year of a term. So I don't feel like any injustice has been done anybody here. And the bottom line, when you read Democratic words from the past, they're saying basically what we said. The one thing I can say is that I've been consistent. I've voted for everybody since I've been here. For Alito, Justice Roberts, Sotomayor, and Kagan, and I feel all 4 had one thing in common. No Republican would have chosen Sotomayor or Kagan, but how could a Republican say they were not qualified for the job they had? They had lived an exemplary life, well qualified, and had years on the bench. Now the shoe is on the other foot. I remember after I voted for Ms. Kagan, all the headlines in the Washington Post were, "This will ensure that Graham gets primaried." They were right. That's not the only reason to my primary opponents, but that was the main reason. And I made it through just fine. And I don't know how we got here as a nation. Scalia had 98-0. Ginsburg, I think, was 96-3. What happened between now and then? How did we go from being able to understand that Scalia was a well-qualified conservative and Ginsburg was a well-qualified liberal and recognized that elections mattered? I don't know how we got there, but here's what I hope, that we turn around and go back to where we were, because what we're doing is going to destroy the judiciary over time.
Thank you, Senator Graham. Now Senator Klobuchar.
Thank you, Mr. Chairman. Welcome, Judge. We've already met once before in my office, and all of us on the Judiciary Committee are looking forward to hearing from you, and welcome to your family as well. This committee has no greater responsibility than the one before us today. Our Constitution, our laws, and our values all depend on a Supreme Court that is impartial, fair, and just. Your nomination comes before us during an unprecedented time in our country's history. We are witnessing a singular moment of constitutional and democratic unease. In recent months, foundational elements of our democracy, including the rule of law, have been questioned, challenged, and even undermined. So I cannot evaluate your credentials in the comfort of a legal cocoon. Instead, I must look at your views and record in the real world of America today. You see, you come before us this afternoon, not only as a nominee sitting at a table alone with your friends and family behind you, but in the context of the era in which we live. From the highest levels of government, we have heard relentless criticisms of journalists. 17 intelligence agencies have confirmed that Russia, an autocratic foreign government, attempted to influence our most recent election. At the same time, voting rights in the U.S. have been stripped from far too many, while dark money in extraordinary sums, adding up to an estimated $800 million in just 6 years, continues to have an outsized influence in our politics, distorting our representative democracy. Just last month, we saw the President of the United States refer to a man appointed to the federal bench by President George W. Bush as a so-called judge. And we have sadly seen hate unleashed towards religious minorities, from Jews to Muslims, venom directed at innocent Americans, from kids in restaurants being told to go back to where they came from, to a man gunned down while washing his car in his driveway. The pillars of our democracy and our Constitution are at risk. You are not the cause of these challenges, Judge, these challenges to our democracy. But if confirmed, you would play a critical role in dealing with them. This is a serious moment in our nation's history, and as representatives of the American people, it is our duty up here to determine if you will uphold the motto on the Supreme Court building itself, to help all Americans achieve equal justice under law. Before I was elected to the Senate, I spent 8 years leading Minnesota's largest prosecutor's office. I've seen firsthand how the law has a real impact that extends far beyond the walls of a courtroom, whether it's crime victims and their families or people who have seen a loved one sent to jail. The decisions made from the bench affect people living right now in the 21st century with 21st century problems. So though the U.S. Constitution and its Bill of Rights were written in the 18th century, though the 14th Amendment's guarantee of equal protection of the laws was written in the 19th century, the decisions made today affect not the lives of our 18th and 19th century ancestors, but of all Americans today. So, Judge, these hearings will not just be about your legal experience. They are about trying to understand what you would actually do on the court. For the law is more than a set of dusty books in the basement stacks of a law library. It's the bedrock of our society. We need to know how you approach the law. After Judge Merrick Garland was nominated to the Supreme Court last year, we often heard about how he is a careful jurist who decides cases on the narrowest possible grounds, who builds consensus across the ideological spectrum, who doesn't inject political considerations into his rulings. We look forward to hearing what your judicial philosophy would be on the court. Looking at your past decisions, I have questions about how you would approach your work. In a speech last year, you spoke about the differences between judges and legislators. You said that while legislators may appeal to their own moral convictions and to claims about social utility to reshape the law as they think it should be in the future, that judges should be none of those things in a democratic society. Judges, you said, should instead strive to apply the law as it is, focusing backward, not forward, and looking to text, structure, and history to decide what a reasonable reader at the time of the events in question would have understood the law to be. I want to understand better those views of the Constitution and how they square with modern-day life. Due process, equal protection of the laws, these are general and sweeping terms, and the Supreme Court, which has the power of judicial review, has the constitutional duty to be the final arbiter of what the Constitution means, rulings that can impact voting rights, civil rights, and the right of people to marry. Many of the issues we face today are ones that this country's founders never considered, and in fact never could have considered because of all the social change and innovation that has taken place. We are no longer dealing with plows, bonnets, and colony debts in England. but instead driverless cars, drones, and cyber crimes. And those were just the topics of the hearings I attended last week. I want to understand how your judicial philosophy, which as you suggest looks backward, not forward, may affect the rights of our fellow citizens. I also want to understand the implications of your views on legal precedent. One example of this occurs in the context of the Chevron doctrine. In stating that courts should generally defer to reasonable interpretations of executive agencies, this 33-year-old case guarantees that the most complex regulatory decisions, ones judges themselves may have little or no expertise to handle, are made by the scientists and professionals best equipped to rise to these challenges. These modern agency decisions include things like rules protecting public safety, requirements against lead-based paint, and clean water protections for our Great Lakes. Last year, in your concurring opinion in Gutierrez v. Lynch, you suggested that Chevron should be overturned. Yet this act would have titanic real-world implications on all aspects of our everyday lives. Countless rules could be in jeopardy, protections that matter to the American people would be compromised, and there would be widespread uncertainty. Judge, if you believe it is really time to overturn Chevron, then we need to know with what you would replace it. Another opinion that I want to talk about is Riddle v. Hickenlooper. In your concurring opinion, you suggest that the court should apply strict scrutiny to laws restricting campaign contributions. If the Supreme Court adopted that view, it could well compromise the few remaining campaign finance protections that are still on the books. The notion that Congress has little or no role in setting reasonable campaign finance rules is in direct contradiction with the expressed views of the American people. In recent polls, over 3/4 of Americans have said that we need sweeping new laws to reduce the influence of money in politics. While polls, as we know, aren't a judge's problem, democracy should be. When unlimited, undisclosed money floods our campaigns, it drowns out the people's voices. It undermines our elections. Other questions about your views in money in politics are raised by your opinion in Hobby Lobby. In that opinion, you found that corporations were legal persons and could exercise their own religious beliefs. This ruling leaves open the troubling argument that corporations have a right to free speech equal to that of citizens, which would invalidate the prohibition of corporations donating. These aren't the only First Amendment issues I'll raise. I want to talk about New York Times v. Sullivan and freedom of the press, as well as an area you have great expertise in, antitrust. Judges, I consider your nomination. I'm reminded of something a justice who hailed from Minnesota, Justice Blackmun, once said. Surely, he wrote, there is a way to teach law, strict and demanding though it might be, with some glimpse of its humaneness and basic good. There is room for flexibility and different answers, and not all is black and white. You see, there's a reason we have judges to apply the laws to the facts. It's because answers aren't always as clear as we would like, and sometimes there is more than one reasonable interpretation. As a prosecutor, I knew that every charging decision that we made, every case we chose to pursue, had real implications. It's the same with judges. For in the end, it wasn't a law professor or federal jurist who was helped by the Eighth Circuit's reliance on Chevron. It was an hourly Minnesota grocery store worker who got his hard-earned pension. And when the court stripped away the rules that opened the door to unlimited super PAC spending, it wasn't the campaign financiers or the ad men who were hurt. It was a grandma in Lanesboro, Minnesota, who actually believed that giving $10 to her senator would make a difference. And as the granddaughter of an iron ore miner, I can tell you it wasn't a CEO or a corporate board chair whose life was saved by mining safety rules. It was the Minnesota iron ore workers, like my grandpa, who went to work every day with a black lunch bucket 1,500 feet underground in a cage. My dad, who ended up as the first kid in his family to graduate from high school and from there to community college and then to the University of Minnesota, still remembers as a little boy standing in front of the caskets of those mine workers lining St. Anthony's Church. It was the worker protections, coupled with the ability to organize as a union, that finally made those miners' jobs safe. Judge, you have been rightfully praised for your impressive academic credentials and experience. But at these hearings, I want to know more than just about your record. I want to know about how, if you are confirmed, your decisions will in fact reflect precedent and the law, whether your judgments and decisions will be good, whether they will be done in a way that will help all Americans, from that grandma in Lanesboro to that Minnesota grocery store worker. That's not politics. That's why we're having these hearings today. Thank you.
Thank you, Senator Klobuchar. Now, Senator Cruz.
Thank you, Mr. Chairman. Judge Gorsuch, welcome. Thank you for your decades of service, honorable service. Thank you for your family being here today. And thank you for your willingness to endure the spectacle of this confirmation hearing. February 13th of last year was a devastating day for those of us who revere the Constitution and the rule of law. On that day, we lost Supreme Court Justice Antonin Scalia. Justice Scalia was one of the greatest justices to ever sit on the court. He was a trailblazing advocate for the original meaning of the Constitution and a shining example of judicial humility. His death left an enormous hole not only in our hearts, but in the protections for the rule of law. And it left enormous shoes to fill, a daunting task that I know weighs on you as you consider the enormity of what is in front of you. Today, there is a sharp disagreement about the very nature of the Supreme Court. Some people view the court as a hyper-powerful political branch. When they grow frustrated with the legislative process and the will of the people, they turn to the courts to try to see their preferred policies enacted. For conservatives, we understand the opposite is true. We read the Constitution and see that it imbues the federal judiciary with a much more modest role than the left embraces. Judges are not supposed to make law. They are supposed to faithfully apply it. Justice Scalia was a champion of this modest view of the judicial role. But had his vacant seat been filled by Barack Obama or Hillary Clinton, Justice Scalia's legacy would have been in grave danger. If they had filled his seat, we would have seen a Supreme Court where the will of the people would have been repeatedly cast aside by a new activist Supreme Court majority. We would have seen a Supreme Court majority that viewed itself as philosopher kings who had the power to decide for the rest of us what policy should govern our nation and control every facet of our lives. We would have seen our democratic process controlled by 5 unelected lawyers here in Washington, D.C. That would have been a profound and troubling shift in the direction of the Supreme Court and in our nation's future. That is why, after Justice Scalia's untimely death, the Senate chose to exercise our explicit constitutional authority. And we advised President Obama that we would not consent to a Supreme Court nominee until the people, in the midst of a presidential election, were able to choose. For 80 years, the Senate had not filled a Supreme Court vacancy that had occurred in a presidential election year, and the Senate majority rightly decided that last year would not become the first in 8 decades. The people, therefore, had a choice between an originalist view of the Constitution represented by Justice Scalia or a progressive and activist view of the Constitution represented by Barack Obama and Hillary Clinton. During the campaign, President Trump repeatedly promised to nominate justices in the mold of Justice Scalia. And indeed, he laid out a specific list of 21 judges, constitutionalists from whom he said he would choose his nominee. Judge Gorsuch was one of those 21. Issuing such a list was a move without precedent in our country's presidential history. And it created the most transparent process for selecting a Supreme Court justice that our nation has ever seen. The voters had a direct choice. The voters understood the 21 men and women from whom the president would pick. And they had a very different vision of a Supreme Court justice that was put forth by Hillary Clinton. And in November, the people spoke. In what was essentially a referendum on the kind of justice that should replace Justice Scalia, The people chose originalism, textualism, and rule of law. The people chose judicial humility. The people chose protecting the Bill of Rights, our free speech, our religious liberty, our Second Amendment, rather than handing policymaking authority over to judges on the Supreme Court. Given that history, given the engagement of the electorate nationally on this central issue, I would suggest that Judge Gorsuch is no ordinary nominee. Because of this unique and transparent process, unprecedented in the nation's history, his nomination carries with it a super legitimacy that is also unprecedented in our nation's history. The American people played a very direct role in helping choose this nominee. Like the renowned justice he is set to replace, Judge Gorsuch is brilliant and has an impeccable academic record. His judicial record demonstrates a faithful commitment to the Constitution and the rule of law. He has refused to legislate his own policy preferences from the bench, while recognizing the pivotal role the judiciary plays in defending the fundamental liberties protected in the Bill of Rights. On the night he was nominated, Judge Gorsuch channeled Justice Scalia when he explained that, quote, "A judge who likes every outcome he reaches is very likely a bad judge, stretching for results he prefers rather than those the law demands." That is exactly right. And those words should give comfort to the American people and to my Democratic colleagues. And it's worth recalling that our friends on the Democratic side of the aisle understand this, and indeed, not too long ago, agreed with it. A decade ago, Judge Gorsuch was confirmed by this committee for the Federal Court of Appeals by a voice vote. He was likewise confirmed by the entire United States Senate by a voice vote without a single Democrat speaking a word of opposition. Not a word of opposition from Minority Leader Chuck Schumer, not from Harry Reid or Ted Kennedy or John Kerry, not from Senators Feinstein, Leahy, or Durbin, who still sit on this committee, not even from Senators Barack Obama, Hillary Clinton, or Joe Biden. Not a one of them spoke a word against Judge Gorsuch's nomination a decade ago. And the question this hearing poses to our Democratic colleagues is, what has changed? What has changed? 10 years ago, Judge Gorsuch was so unobjectionable, he didn't merit even a whisper of disapproval. In the decades since, he has had an objectively exemplary record. By any measure, he has shown himself to be even more worthy of the bipartisan support he received back then. Unfortunately, modern reality suggests that's probably not something my Democratic colleagues feel they can do in today's political environment. Many probably believe they have no choice but to try to manufacture attacks against Judge Gorsuch, whether they want to or not, just to preserve their own political future and protect themselves from primaries back home. We are seeing some of these baseless attacks already. Most recently, some Democrats have tried to slander Judge Gorsuch as being, quote, against the little guy because he has dared to rule based on the law that Congress has passed, and not on the specific identity of the specific litigants appearing before him. This is absurd. For one thing, many of these same critics have spent the last 8 years attacking the Little Sisters of the Poor, a Catholic charity of nuns, for having the audacity to live according to their deeply held religious beliefs. You really need to take a long look in the mirror if one day you find yourself attacking nuns, attacking the Little Sisters of the Poor, and then the next day you find yourself orating on the need to protect the little guy. A judge's job is not to protect the little guy or the big guy. A judge's job, and a judge swears an oath to uphold the Constitution and to follow the law fairly, impartially, and equally for every litigant, little or big. In the past weeks as well, some of my Democratic colleagues have questioned Judge Gorsuch's independence and suggested that he needs to answer questions about the actions and statements and even the tweets of the president who appointed him. I would ask, was Justice Ginsburg or Justice Breyer asked about the sexual harassment suit that had been filed against President Clinton by Paula Jones? No, neither was asked about that suit. Was Justice Kagan asked about President Obama's incendiary comments at the State of the Union attacking the Supreme Court for a decision he disagreed with? No, of course not. Those questions were not asked because they were inappropriate political questions that have nothing to do with the record of the nominee before this committee. Justice Ginsburg, Justice Breyer, Justice Kagan were not asked those questions, and Judge Gorsuch should not be either. Instead, we should evaluate this nomination on the record, on the merits, and on that ground, I have every confidence that Judge Gorsuch will be confirmed as the next Associate Justice of the Supreme Court.
Senator Cruz, now Senator Franken.
Thank you, Mr. Chairman. Judge Gorsuch, congratulations on your nomination. You're a man of considerable qualifications and experience, and having reviewed your decisions, I can say that you're a man of strong opinions. But the task before this committee is not to determine whether you are a man of conviction. Rather, it is incumbent upon us to determine whether the views that you espouse and whether your interpretation of the Constitution take proper measure of the challenges the American people face every day. We must determine whether your understanding of our founding document is one that make real its promise of justice and equality to all Americans, black and white, immigrant, Native American, gay, straight, and transgender. We must determine whether your interpretation of our laws and the Constitution will unfairly favor corporate interests over working families or limit the ability of Minnesotans to get their day in court. The justices who sit on the Supreme Court wield enormous power over our daily lives, and so before this committee decides whether to advance your nomination, we have an obligation to fully examine your views on these important issues and to make sure that those views are known to the public. That's really the whole purpose of these hearings, to allow the people of Minnesota, the American people, to meet you, to decide for themselves whether you are qualified to serve. But Judge Gorsuch, having reviewed your decisions and your writings, I have concerns. In the days ahead, I will use this hearing as an opportunity to better understand your views and perhaps to alleviate those concerns. But in order for the hearing to serve its purpose, in order for the public to determine whether you should be confirmed, you must answer the questions this committee poses fully, candidly, and without equivocation. So I hope that's how you will approach our exchanges. Now, with that in mind, I think it's important to acknowledge just exactly how it is that you came before us today, and we talked about this, namely the committee's failure to fulfill one of its core functions immediately following the death of Justice Scalia and before President Obama even named a nominee. My Republican colleagues announced that they would not move forward with filling the vacancy until after the presidential election. The majority leader said, and I quote, "The American people should have a voice in the selection of their next Supreme Court." The only problem with the majority leader's reasoning is that the American people did have a voice in this decision twice. Nonetheless, when President Obama nominated Chief Judge Merrick Garland, the Republican members of the committee responded by refusing to hold a hearing, a truly historic dereliction of duty of this body and a tactic as cynical as it was irresponsible. As a result of my Republican colleagues' unprecedented obstructionism, Justice Scalia's seat on the court remained vacant until President Trump was able to name a replacement. Now, during the campaign, then candidate Trump made no secret about what kind of nominee he would select. In fact, he openly discussed his litmus test. He said that he would, quote, appoint judges very much in the mold of Justice Scalia. During the final presidential debate, then candidate Trump said, quote, the justices I'm going to appoint will be pro-life, they will have a conservative bent. Now, Justice Scalia was a man of great conviction and, it should be said, a man of great humor. But Justice Scalia embraced a rigid view of our Constitution, a view blind to the equal dignity of LGBT people and hostile to women's reproductive rights, and a view that often refused to acknowledge the lingering animus in laws and policies that perpetuate the racial divide. Judge Gorsuch, while no one can dispute that the late Judge Scalia's love of the Constitution, the document he revered looks very different from the one that I have sworn to support and defend. So it troubles me that at this critical juncture in our nation's history, at this moment, when our country is so fixated on things that divide us from one another, that President Trump would pledge to appoint jurists whose views of our founding document seek to reinforce those divisions rather than bridge them. This is an important moment in our history. The public's trust in our government and in the integrity of our institutions is at an all-time low. But that erosion of trust didn't take place overnight, and it didn't happen on its own. The American people's loss of confidence in our public institutions was quickened by the court. A study published in the Minnesota Law Review found that the Roberts Court is more likely to side with business interests than any Supreme Court since World War II. Time and time again, the Roberts Court issued decisions that limit our constituents' ability to participate freely and fairly in our democracy. Decisions like Shelby County, where the court gutted one of our landmark civil rights laws and removed a crucial check on race discrimination at the ballot box. Or like Concepcion, a 5-4 decision that allows corporations to place obstacles between consumers and the courthouse door. Perhaps most egregious of all was Citizens United, which paved the way for individuals and outside groups to spend unlimited sums of money in our elections. It's no surprise that during the 2016 elections, voters from across the ideological spectrum, Democrats and Republicans alike, described our system as rigged. That's because it is. And the Roberts Court bears a great deal of responsibility for that. Now, in each one of those 5-4 decisions, Justice Scalia was among the majority. So as this committee sets about the task of evaluating his potential successor, I want to better understand the extent to which you share Justice Scalia's judicial philosophy, and I will be paying close attention to the ways in which your views set you apart. One of the ways in which your views are distinct from Justice Scalia's is in the area of administrative law. Just this past August, you wrote an opinion in which you suggested that it may be time to reevaluate what's known as the Chevron doctrine. Now, in broad strokes, the Chevron doctrine provides that courts should be reluctant to overrule agency experts when they are carrying out their missions, like when the FDA sets safety standards for prescription drugs. This principle, outlined by the Supreme Court, recognized that our agencies employ individuals with great expertise in the laws that they are charged with enforcing, like biologists at the FDA, and that where those experts have issued rules in highly technical areas, judges should defer to their expertise. Now, administrative law can be an obscure and sometimes complicated area of the law, but for anyone who cares about clean air or clean water or about the safety of our food and of our medicines, it's incredibly important. And Chevron simply ensures that judges don't discard an agency's expertise without good reason. Justice Scalia recognized this to be true. But to those who subscribe to President Trump's extreme view, Chevron is the only thing standing between them and what the President's chief strategist, Steve Bannon, called the quote-unquote deconstruction of the administrative state, which is shorthand for gutting any environmental or consumer protection measure that gets in the way of corporate profit margins. Speaking before a gathering of conservative activists last month, Mr. Bannon explained that the President's appointees were selected to bring about that deconstruction, and I suspect that your nomination, given your views on Chevron, is a key part of that strategy. So this hearing is important. Over the next few days, you'll have an opportunity to explain your judicial philosophy, and I look forward to learning more about how you would approach the great challenges facing our country. But if past is truly prologue, then I fear that confirming you would guarantee more of the same from the Roberts Court. Decisions that continue to favor powerful corporate interests over the rights of average Americans. During your time on the 10th Circuit, you have sided with corporations over workers, corporations over consumers, and corporations over women's health. What this moment in our history and our nation's history calls for is a nominee whose experience demonstrates an ability to set aside rigid views in favor of identifying common ground and crafting strong consensus opinions, someone like Merrick Garland. But your record suggests that, if confirmed, you will espouse an ideology that I believe has already infected the bench, an ideology that backs big business over individual Americans and refuses to see our country as the dynamic and diverse nation that my constituents wake up in every morning. As I said before, I see this hearing as an opportunity to learn more about your views and perhaps to alleviate some of my concerns. I hope that we are able to have a productive conversation. Thank you, Mr. Chairman.
Before the senator from Nebraska goes, I haven't talked to the person sitting there and can't get up and go, but I think when you're done, we'll take 5 minutes and you can do whatever you want to do. Go ahead, Senator from Nebraska.
Thank you, Mr. Chairman. Judge, this is a special moment in the life of our republic. We have an opportunity to stand back from more than 200 years of our history, to evaluate our civic health, and to recommit ourselves to a government that is intentionally limited, to powers that are intentionally distinguished and divided. That's what these next few weeks are actually about. Arguably, the most important thing the U.S. Senate will do this year is confirm the next Supreme Court justice. I want to focus my opening remarks around the simple image of a judge's black robe. It's a strange thing that judges wear robes. You people are odd. But it isn't something that we should just look past as an odd convention. It's something that we should look right at. It's not some relic from history that people wore long ago in an era of formality, like a powdered wig. So why do the robes exist, unfashionable and unattractive as they often are? The reasons are better summed up by a current sitting judge than I might be able to put them. And so I quote, "Donning a robe doesn't make me any smarter, but the robe does mean something. It's not just that I can hide the coffee stains on my shirt. It serves as a reminder of what's expected of us, what Burke has called the cold neutrality of an impartial judge. It serves, too, as a reminder of the relatively modest station we're meant to occupy in a democratic society. In other countries, judges might wear scarlet. Here, we're told to buy our own plain black robes, and I can attest to the standard choir outfit of the local uniform supply store as a good deal. Ours is the judiciary of an honest black polyester," close quote. The author of these insightful words sits before us, Judge Neal Gorsuch. And that statement is an excellent lens through which to view the work of the committee this week, and indeed the work of the court over the next century and beyond. I want to make 3 simple overlapping points about that judge's black robe. 1, it changes the way that our eyes see the court. 2, it reiterates the calling of a judge to the judge. And 3, it gives us a special opportunity to teach our kids something about their Constitution, the enduring paper that defines what our government can and cannot do. First then, how does it change the way we see the court? When you look at the 9 justices sitting together in their robes, they blend in with one another. It's hard to tell them apart if you squint, and thus it calls attention to the office rather than to the person. That's because when the judge puts on his or her robe, it forces their personalities into the background so that we can focus on the important but the modest job that they have to do, which is to drill down on facts and law. Facts are objective. They don't change based on your personality. They're evaluated against written objective laws, not against what the judge wishes the law said. Someone famously said that, quote, empathy close quote, is an essential ingredient in arriving at a just decision. This belief is well meant, but it's very foolish. For standing before a court, your gender, your skin, your bank account cannot decide your fate. In the same way, a judge's race, class, and gender should not decide your fate. Empathy is actually not the role of a Supreme Court justice. It is, in a sense, our role, for we are men and women who've been hired and can be fired by the American people to empathize. We're to identify with the hopes and the struggles of 320 million Americans. But the judge, instead, has a different job, to faithfully and dispassionately apply the law to the facts of the particular case. The judge's robe is there to remind the judge and us of that if the facts are on your side, it shouldn't matter which judge you sit before. Our ideal is one where you can trade out one judge for another judge, and you should get the same outcome. This is the heart of what we mean when we say that we believe in the rule of law, not of men, or of women, or of black or white, or rich or poor. We are not to be ruled by a judge's passions, or by a judge's empathy, or by a judge's policy preferences. Here's the second thing that the black robe is supposed to do. It's supposed to reiterate the calling of the judge back to the judge. By way of loose analogy, many people across our country sat in church pews yesterday morning and listened to someone preach from behind a big wooden pulpit wearing a robe. Why the pulpit? Why the robe? Because these things make it harder to see the preacher. They help us all understand that yesterday morning, for those of us in that tradition, knew that it was not about the messenger, but about the message that was being passed on from above. It was also to remind the minister of the same cloaking. Likewise, a good judge on the bench knows that. It's not about you, so don't make it about you. I said that it's only a loose analogy because, of course, the job of a Supreme Court justice is absolutely not to deliver some eternal word from God. It's rather to interpret a man-made written constitution as objectively and faithfully as they can, inserting their opinions as little as possible. When you put on your robe, you're cloaking your personal preferences. You're cloaking your partisan views. There's not a red robe for Republicans. There's not a blue robe for Democrats. We issue here only black robes. This brings us to the third and final point, which is that the judge's robe is also to teach our kids how they should understand their Constitution. As all of us learned in Schoolhouse Rock, the judiciary is not only a separate branch of government from the president and the Congress, but it's also a co-equal one. We have different functions, but we have the same responsibility to be upholding and to teach the Constitution. As a co-equal, the court can examine whether the actions of the other two branches are in fact unconstitutional. Time and again, at important moments in our nation's history, the court has struck down laws passed by the Congress or put a stop to a president's executive actions. Here's what that means. The primary job of the Supreme Court is not to uphold the will of the majority of the moment. The primary job of a Supreme Court justice is not to reflect the popular opinions of the day. That might sound surprising. Don't we live in a democracy where the majority is supposed to rule? The answer to that question is only a very qualified yes, for there are critical limits to that statement. The Constitution is a decidedly and intentionally anti-majoritarian document. The Constitution exists to protect our rights and our liberties, even when we might hold unpopular views. And the role of the Supreme Court in protecting those rights and liberties is sometimes precisely to frustrate the will of the majority. Think about how the Constitution deals with religion and public opinion. The First Amendment prohibits the government from establishing any state religion, and it guarantees that every citizen can worship or not worship however their conscience dictates. If, however, at some moment polling showed a 51% popular desire in this country to pass a law making church attendance mandatory or to subsidize a particular religious denomination, the Supreme Court would rightly strike down such flawed laws. This is because in the Constitution, we decided that we would limit our own power. We, the people, decided in the founding of this republic that we would restrain our own majoritarian impulses. By enacting the Constitution, we intentionally decided to tie our own hands so that there are certain things that a majority can never do, like invade someone's conscience. And if the majority, in its arrogance, should at some point in the future seek to cross that line, the Supreme Court will rightfully shout no. When Congress passes an unconstitutional law, it is in fact the Congress that is violating the long-term will of the people. For the judiciary is there to assert the will of the people as embodied in our shared Constitution over and against that unconstitutional, but perhaps temporarily popular law. Each branch serves the people, but in unique ways. It is the job of the Congress and the President to act. It is the job of the court often to react. Each branch holds the others in check. Each branch faithfully seeks to uphold and teach the Constitution. Each branch serves the American people, but with distinct offices. When a Supreme Court justice puts on his or her robe, we don't want them confusing their job with those of other branches. We want them policing the structure of our government to make sure that each branch does its job, but only its job. Today, Judge Gorsuch sits in front of us wearing a suit and tie. Before he can put back on the black robe, he must answer this committee's questions. And I expect that Mr. Gorsuch, the citizen, has policy preferences. He probably has desired outcomes, but I don't know what they are, and that's a good thing. And I expect by the end of this week, it should be clear that Judge Gorsuch, the judge's judge, will faithfully embody the spirit of that black robe. For the American people deserve the comfort of a judiciary that is cold and impartial, not seeking to be super legislators. For if a judge seeks to be a super legislator, he or she should run for office so the American people can choose to hire them or fire them. But that is not the calling you have before us today. Thank you, and thank you to your family for being willing to endure this calling and this service and this hearing.
In 4 minutes and 59 seconds, I'll call on Senator Coons. Stand at ease. The judge isn't here yet, but if you take your seats, he will be momentarily, and then we'll start with Senator from Delaware. This isn't meant to be funny. But if it bothers my colleagues, I'll stop it. Coons will be next as soon as our nominee gets here. Senator Coons, would you proceed, please?
Thank you, Mr. Chairman. Welcome, Judge Gorsuch, and welcome to your family and your friends. Congratulations on your nomination, and I look forward to the opportunity to question you. I believe my constitutional duty to advise the President on this nomination of the Supreme Court is among my most important responsibilities as a senator. A nominee confirmed to the Supreme Court shapes our law for decades. Justices decide cases that influence the lives of generations of Americans. This hearing is our opportunity to ask you, Judge Gorsuch, questions in front of the American people to better understand how you interpret the text of our Constitution and how you apply Supreme Court precedent. We'll explore how your approach to interpreting our Constitution would impact our lives in the future. I'm committed to ensuring the consideration of your nomination by this committee is thorough and fair, and I'm hopeful that as our hearing proceeds, it'll promote an important dialogue about the Constitution and the courts. Based on our meeting, Judge Gorsuch, I know that you too hope that this moment can serve as a shared civic experience. I am considering your nomination with an open mind, and I would ask that you be forthcoming in your responses to our questions. I'd like this hearing to be substantive and to reflect the best traditions of the Senate. However, I cannot let this moment, in commenting on the best traditions of the Senate, pass without expressing my deep regret that Chief Judge Merrick Garland was treated with profound and historic disrespect. The disrespect shown by Senate Republicans to Chief Judge Merrick Garland and to President Obama and to our institutions was unprecedented and deeply damaging. For nearly 300 days, longer than any other nominee, Chief Judge Garland's nomination to the Supreme Court sat without action. My Republican colleagues didn't afford him a hearing and would not give him a vote. I believe we have a responsibility to work to re-elevate our democratic institutions above these narrow partisan politics. I will support a process worthy of its important purpose to carefully evaluate a candidate for the highest court in the land. The American people are entitled to see you answer probing, thorough, and challenging questions about your views on a wide range of constitutional issues, because the breadth of the issues that come before the Supreme Court can't be overstated. Just in the last year, the Supreme Court considered cases involving executive power, affirmative action, intellectual property, partisan gerrymandering, racial bias in the courtroom, and reproductive rights. The seat you would fill, Judge Gorsuch, if elevated, was occupied by Justice Scalia, and you've been compared to him. While it may seem at times to many that the Supreme Court is engaged in abstract intellectual exercises about originalism or textualism or a living constitution, even a small subset of landmark decisions Justice Scalia took part in during his nearly 30 years on the court demonstrates otherwise. It's because of Supreme Court decisions that gay men can no longer be criminally prosecuted for engaging in consensual relationships, that loving same-sex couples can get married in every state in our union, that women cannot be denied attendance at one of the nation's premier military academies, and that women are entitled to access the full range of reproductive health care, that juveniles and intellectually disabled people can no longer be executed, and that millions of Americans who obtained health insurance under the ACA have been able to keep that care, at least for now. These cases impacted the lives of millions of real Americans, and Justice Scalia applied his understanding of the Constitution and dissented in every one of them. I'd like to use these hearings to explore your interpretation of the Constitution. I believe that our Constitution, which I view as our nation's secular scripture, includes guarantees of equality and privacy, hallmarks of our modern American society. I believe in an independent judiciary that safeguards our rule of law from unlawful intrusions of the most powerful, even the President of the United States. The legitimacy of our Supreme Court transcends the outcome of any one case, but that legitimacy rests on the unyielding responsibility of justices to put their personal political views aside to decide cases on their merits. Judge Gorsuch, your nomination has been championed by the ideologically driven Federalist Society and Heritage Foundation. Interest groups are already spending millions of dollars advocating for your confirmation. But as I've told you during our meetings, none of those facts will determine my vote on your nomination. I'm instead looking to you to demonstrate your ability to separate politics from constitutional interpretation. As my colleague from the state of Utah, Senator Hatch, once noted, judges that say what the law is promote liberty. Judges that say what they think the law should be undermine it. I've spent a good deal of time reviewing your record. I appreciate that you're an engaging and careful writer. I also have some serious questions based on your decisions. What stands out to me is your tendency to go beyond the issues that need to be resolved in the case before you. I've seen a pattern in which you file dissents from denials of rehearing, concurrences, or even concurrences to your own majority opinions, to explore broader issues than what's necessary, to revisit long-settled precedent, and to promote dramatic changes to the law. This pattern concerns me because these additional writings hint at an unwillingness to settle on a limited conclusion and forge a narrow consensus with your colleagues. I want to know that you would apply the Constitution and settle precedent to reach consensus and resolve narrowly the disputes before you. and I want to know that our treasured freedoms would be safe in your stewardship. Our Constitution, as you know, is designed to protect our diversity of views. It guarantees to all of us the freedom of expression, the right to privacy, the liberty to make our most personal life decisions, equal protection, and the ability to worship freely. Take the freedom of religion enshrined in the First Amendment, which says in part, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. I believe we must balance our respect for the significance of faith and free exercise with concerns about impacts on others' liberty. As my colleagues know, I studied both law and divinity in school, and some of the most formative and meaningful experiences of my life have been guided by my Christian faith. The command to care for the most vulnerable among us inspires my work and service as a senator, and I value opportunities to share with my colleagues in prayer. Throughout our nation's history, religion has inspired countless acts of charity, kindness, and good works. But when I think about the founders' wisdom to protect both church and state by ensuring their separation, I'm in awe. Our United States were founded by people who came here for many reasons, seeking opportunity, freedom from oppression, and hoping, in many cases, to be free to practice their faith. From pilgrims to Mormons, from the Amish to Jehovah's Witnesses, America, from its founding to today, has been home to many faiths from many parts of the world, and part of our founders' genius was to abandon the European practice of having a state religion supported by state taxes. Now today, across the U.S., churches and mosques, synagogues and temples find their own way, recruit and raise up their own believers and funds free from state interference and unsustained by state support. The Supreme Court over decades has sought to strike and preserve a careful balance between the free exercise rights of religious minorities and the power of legislatures to compel compliance with neutral laws. Recently, the court has decided several landmark and controversial cases. In the Hobby Lobby case, where the free religious exercise rights of a few were held to permit the infringement on personal liberty of many. And in another important line of cases in which substantive due process rights have been held to guarantee a right to privacy and self-determination, even when long-standing practices and religiously motivated statutes are challenged as a result. I look forward to exploring these decisions with you. Religious freedom must be freedom not to have our values and practices pushed into the public square. While other nations are besieged by sectarian wars, inclusion of all faiths and all people have been guiding lights in the success of our democracy. However, at other times in our history, sincerely held religious beliefs have been invoked to deny millions of Americans full equality under the law, in defense of laws prohibiting interracial marriage or LGBT relationships or reproductive rights. We live today in tumultuous times, as you know, Judge. The Supreme Court's likely to hear many important cases in the years to come. It'll be important that we understand your values and framework for interpreting the Constitution on areas as important as executive power, national security, the independence of the judiciary, deference to agencies, and personal liberty. There are disturbing developments that I see in our modern environment as affronts to religious freedom and personal liberty. President Trump campaigned on putting in place a Muslim ban and has signed unlawful and discriminatory executive orders to deliver on that promise. The new administration's Justice Department has withdrawn guidance supporting protections for transgendered individuals. And the Attorney General testified under oath at his confirmation hearing before us that secular attorneys may not have the same claim to understanding the truth as religious ones. Our next Supreme Court justice will play a pivotal role in sustaining and defending our rights during this critical time for our country and in the years to come. America needs a Supreme Court justice who will protect the Constitution, not one who will countenance the faith or fear of some as a justification for infringing the liberty of many. It's against that backdrop, Judge, that I will be seeking to understand your commitment to the rule of law, the guarantees of the First Amendment, and individual liberty. I look forward to your testimony. Thank you.
Thank you, Senator Coons. Now I go to Senator Flake.
Thank you, Mr. Chairman, and thank you, Judge Gorsuch. Thank you for being here, and thank you to your family as well and your many friends and associates who have come to support you. It says a lot for you to have so many willing to be here, and I've been astounded at the number of op-eds I've read and statements I've heard from those, not just those that you agree with, but those who don't always agree with you. That says a lot about you. I had a speech to deliver a while ago, and when it was fed into the teleprompter, your name wasn't as familiar as some.
and it replaced it with Judge Grouch throughout the entire time, and I had to be careful. But let's. I think it's safe to say by the end of this week, every spell checker in the country will know your name, and Judge Grouch is about as far as you can get from Judge Gorsuch in terms of your temperament. So I commend you. That may change by the end of the week as well, though, I have to say. But I don't think so. As we all know, one of the most consequential decisions a president makes is who he or she will select to fill vacancies on the Supreme Court. This is a lifetime appointment. It means that a man or woman who is selected will likely be interpreting our laws for decades to come. Judge Antonin Scalia demonstrated how much one justice can impact and shift the gravity of the court. And no justice in recent memory has so fundamentally influenced the trajectory of the Supreme Court or our approach to reading the law. He did this with an unshakable commitment to an originalist interpretation of the Constitution and a textualist approach to statutes. Judge Scalia's passing marked a watershed moment for the future of our judiciary. One law professor remarked, quote, "Who lets the legal system survive is that people, what lets the legal system survive is that people in power such as Scalia believe that the system controls their individual judgments. What will happen to the law without Justice Scalia to believe in it?" Now, fortunately, the president has nominated a jurist who believes in the rule of law. Now, in meeting with Judge Gorsuch and learning about his judicial philosophy, I was impressed by his respect for the law and his commitment to service. I've been particularly struck by his recognition that, quote, "it is for Congress, not the courts, to write new law, and that a justice should make decisions based on what the law demands, not an outcome he or she desires." As we discussed in my office, you said that when you don that black robe that Ben Sass talked about, you understand that you are not a legislator. That is important. It was brought up before that one of my colleagues says that Judge Gorsuch is pro-business or against the little guy. I think the record suggests that he faithfully applies the law and the laws as enacted by Congress. Good judges don't decide cases based on how big the guy is, but based on the law and the facts. Now, I'm not alone in thinking that. Harvard law professor Noah Feldman, a self-described liberal, recently wrote that, quote, "siding with workers against employers isn't a jurisprudential decision, it's a political stance. And justices, including progressive justices, shouldn't decide cases based on who the parties are." I think Judge Gorsuch's opinions show just that. He decides cases based on what the law says, not who the parties are. Judge Gorsuch has repeatedly reminded us that while we as legislators may appeal to our own moral convictions in shaping the law, judges in a democratic society should not decide cases based on their own moral convictions or their policy preferences. With Judge Gorsuch, I think the record shows that we can be confident that he will read the law as written and not legislate from the bench. With regard to the separation of powers, Judge Gorsuch has cautioned against, quote, "governmental encroachment on the people's liberties, which could occur should the political majorities of the legislative and executive branches be permitted to decide cases and the political unresponsive judiciary branch be allowed to create or execute policies." For my part, I'm excited to confirm a justice who reveres the separation of powers as a central principle of our Constitution. Judge Gorsuch has also demonstrated support for religious liberties. Our country has always valued the right of individuals to practice their faith according to the dictates of their own conscience. He once wrote that our religious freedom statute, quote, "don't just apply to protect popular religious beliefs, it also it does perhaps its most important work in protecting unpopular religious beliefs, vindicating this nation's long-held aspiration to serve as a refuge for religious tolerance." The Supreme Court later agreed with Judge Gorsuch that it is the government's job to protect an individual's ability to practice their religion, not to instruct them how to practice their religion. Now, finally, as an Arizonan, I'm proud of the fact that Judge Gorsuch is a fellow Westerner.
Where you're from influences your understanding of cultural and regional sensitivities, and the current markup of the Supreme Court has an unmistakable lack of geographic diversity. Of the 8 current justices, 5 of them were born in New York or New Jersey. As we say in Arizona and elsewhere, New York City. This is nice to have someone from the West with a Western perspective, and fortunately, Judge Gorsuch fits that bill. When I met Judge Gorsuch earlier this week, we talked about our respective Western backgrounds. I told him about my days growing up on a cattle ranch in rural Arizona. He told me that his heart has always been in the American West. You learn a lot about a person by how they spend their time with their friends and family. There's no mistaking it with Judge Gorsuch. He's a Westerner through and through. Now, what makes Judge Gorsuch a true Westerner is more than just where he lives or what his personal interests are. In the West, we pride ourselves on being a free people with strong communities and limited government. Judge Gorsuch's jurisprudence reflect that what every Westerner knows to be true. An intrusive federal government can interfere with the ability of Western states to govern themselves. And perhaps more than anything, it will be Judge Gorsuch's Western perspective that most enriches debate on the Supreme Court for years to come. Now, there's been a lot said about what happened last year with the nomination of Merrick Garland. I find it striking and very revealing that one of the first calls that Judge Gorsuch made when he received this nomination was to Merrick Garland, his friend. I think that says a lot about the man, regardless of any of our thoughts, and certainly what happened here shouldn't reflect on Judge Gorsuch. But I appreciate the temperament that you have and your willingness to subject yourself and your family and friends to this process, and I look forward to the rest of the hearing. I yield back.
Thank you, Senator Flake. Now, Senator Blumenthal.
Thank you, Mr. Chairman. Thank you for being here, Judge. I live in the western part of Connecticut. I love Colorado, and my first job was on a farm in Nebraska where my grandfather raised corn and cattle. Yeah. So we can go into other commonalities, but I want to join in thanking you and your family and say that despite the hardships of going through this process, I suspect there are quite a few lawyers in Connecticut who wouldn't mind changing places with you. But I also want to thank one group that perhaps should be given gratitude, and that is your fellow judges on the federal bench. Some of them are here. I have no doubt that many are watching. I've had the honor in the last 40 years to appear before many of them, and they make sacrifices that are often unappreciated by most Americans who enjoy the benefits of their service, often financial sacrifices, personal sacrifices, sometimes even physical threats, as happened when the schools were desegregated or when women's clinics were protected in the United States. And so I want to thank them and through you express my gratitude. The independence of those judges has never been more threatened and never more important. And a large part of the threat comes from the man who nominated you, who has launched a campaign of vicious and relentless attacks on the credibility and capacity of our judiciary to serve as a check on lawless executive action. His demeaning and disparaging comments about the judiciary have shaken the foundations of respect for judicial rulings, rulings that hold the president accountable to the people and our Constitution. Respect for the opinions of our judges is fundamental, as you well know. Without it, our democracy cannot function. Alexander Hamilton said that the judiciary is the least dangerous branch because it has the power of neither the purse nor the sword. Essential to its power to protect us is its respect and trust and credibility, and the President has gravely undermined it. And that is why I believe you have a special responsibility here this week, which is to advocate and defend the independence of our judiciary against those kinds of attacks. It isn't enough to do it in the privacy of my office or my colleagues behind closed doors. I believe that our system really requires and demands that you do it publicly and explicitly and directly. We meet this week in the midst of a looming constitutional crisis. Just hours ago, not far from here, the director of the FBI revealed that his agency is investigating potential ties between President Trump's associates and Russian meddling in our election. The possibility of the Supreme Court needing to enforce a subpoena against the president is no longer idle speculation. It did so in United States v. Nixon. So the independence of the judiciary is more important than ever, and your defense of it is critical. You are also the nominee of a president who set a set of litmus tests, saying that his nominee would be pro-life and pro-Second Amendment and of a conservative bent. In fact, he said that he would nominate someone, and I'm quoting almost exactly, in one of the debates, who would automatically overturn Roe v. Wade. So again, if you fail to be explicit and forthcoming and definite in your responses, we have to assume that you will pass the Trump litmus test. Your nomination also imposes on you a special burden because of the process that brought you here. The President has largely outsourced the selection process to conservative groups. He specifically referred to them on May 11th when he said that a list would be prepared by the Heritage Foundation and the Federalist Society. On June 13th, he said, quote, "We're going to have great judges, conservative, all picked by the Federalist Society," end quote. You must be clear that your views are not theirs. And while under ordinary circumstances, this committee might be satisfied with the platitudes of "I cannot reach conclusions or state conclusions because of the possibility that I may have to consider a case before the court," these times are not ordinary. The rule of law is more than the pillars and the judicial robes that people ordinarily associate with the United States Supreme Court. Justice has a human face and a voice, and as you know from being in the trenches, real clients with real lives, and the law has real consequences in their lives. I met with Alphonse Madden, the trucker who was fired by Trans Am Trucking when he left his truck in sub-zero weather. That truck was disabled. It couldn't be driven, and he was freezing. I met with Patricia Kaplinger, who was denied relief by your court after suffering very serious injury resulting from a defective product use. I met with the children of Grace Wong, who was denied leave by Kansas State University, even though she was suffering from cancer. I'm troubled by the results in those cases for those real people, but also for the broader issues that those decisions reflect in workers' safety and consumer protection, as well as the rights of women to health care and reproductive decisions that are protected by the Fourth Amendment. And the right of privacy goes beyond just women's health care. It also relates to surveillance and government snooping, and a right that is central to our democracy. Let me just close by saying that you have a special obligation to be forthcoming about your views, not to prejudge the merits of a particular case before the court, but to share your views on long-standing precedent that the president who nominated you indicated would be overturned. And you have an obligation to be forthcoming as well, because the decision before us is not about Justice Scalia, nor is it about your confirmation 10 years ago. The Supreme Court is different. The Supreme Court is the ultimate resort of justice in this country. And as much as you may have encountered little difficulty 10 years ago, you now have a record. And we are here to judge that record and to make sure that our decisions, and I agree with my colleagues that it will be probably one of the most consequential and profoundly important decisions that I make as United States Senator, is the right one for the country, and will, above all, make sure that the rule of law is preserved for real people with real lives, and that we assure that the independence of our judiciary will continue to protect us from overreaching and tyranny and the constitutional crisis that is now a real danger before us. Thank you for being here. Thank you, Mr. Chairman.
Thank you, Senator Blumenthal. Now, Senator from Idaho.
Thank you, Mr. Chairman. Judge Gorsuch, welcome, and congratulations on the high honor of your nomination. Much of the discussion surrounding this nomination has centered on answering the key question: what kind of justice should serve on the United States Supreme Court? Some want a judge in their own making, predictable, ideological, and political. Others regard the role of a judge as a final arbiter of justice, clothed in those dark black robes, unquestioned, and seated on an elevated platform well above the court proceedings. In recent years, selecting judges has become more about a numbers game, with the courts measured at least in part by comparing vacancies filled by each president. Often, in fact, as recent as last week and this week, we read about federal court proceedings, invariably coupled with the name of the judge and the president who appointed him or her. Because venue shopping has become all too common a practice today, the individual judge can become more important than the facts of the case. In this scenario, the judge serves not justice, but politics in another form. Whenever Congress considers a judicial nomination, people talk earnestly about the importance of independence. For some, that word flows from the central work of the founders of our Constitution, who created a separate branch of government empowered to review laws passed by the legislature and signed and executed by the president in the executive branch. To others, independence is more about giving judges the power to issue decisions without personal consequence. The true American vision of justice is one in which the judge fairly and impartially finds the facts and applies the law. The law is supreme. The facts decide the day. The judge could be substituted with another and the outcome remains the same. The president who nominated him or her is never mentioned in the article about the decision, and venue shopping is a relic of another era. This is the vision most Americans have of the proper judge on the federal bench. As I reflect on the nomination of Judge Gorsuch, I think back to our meeting soon after his nomination was announced. I've met several Supreme Court nominees in my service in the Senate. All of them have impressive credentials and legal experience. But Judge Gorsuch stands out for a notable reason. He understands and is focused on the principle that a judge is the servant of the law, not the maker of it. One of his comments during our visit still resonates with me. He said, "My personal views are irrelevant as a judge. Isn't that the ideal illustration of a judge steadfastly committed to the law? To quote the late Justice Scalia, if you're going to be a good and faithful judge, you have to resign yourself to the fact that you're not always going to like the conclusions you reach. If you like them all the time, you're probably doing something wrong. Judge Gorsuch recognizes that the law may be imperfect, being the product of an imperfect system. But there is a remedy to the imperfection of law: the political system, directly accountable to the public. The people choose policymakers, not federal judges. The law can frustrate. In black and white, it is stark, and change comes slowly and often deliberately, just as our forebears designed. Law that can change in a moment and capriciously is inherently destabilizing. An activist judge who makes law plants insecurity in our system. Rather, our Constitution provides for law to be enacted legislatively with the sanction of the American people through the ballot box. Policy changes advanced by judges can be reversed, and reversed again. Law properly grounded in the democratic and political process cannot. Equal protection under the law. Justice is blind. These aren't just catchy phrases that echo back to our time in civic classes. These are guiding principles of our republic and reaffirmed in the 14th Amendment to our Constitution. Fundamentally, each of us should know courts will find for us when the law is on our side. Whether we are rich or poor, strong or weak, or a big guy or a little guy. That's principled justice. Some may not like a particular law. That's fair and not unexpected. But the remedy for this disagreement is not changing judges, but changing the law. Fortunately, our system of government has the exact solution available to us: passing a new law through deliberate, careful, and publicly accountable political processes. No one seriously questions Judge Gorsuch's fitness and capability to serve on the highest court in our land. His credentials are exemplary. He is widely respected for his intellect, his judgment, and his modesty. His admirers span the political spectrum. Judge Gorsuch is intelligent and open-minded. He is exactly the model for an appointment to the United States Supreme Court. Mr. Chairman, I look forward to hearing from the nominee himself. The next few days will prove extraordinarily insightful as we discuss with Judge Gorsuch his philosophy of jurisprudence, what animates him to interpret the law, and his vision for the federal judiciary. I look forward to this hearing. Thank you very much, Mr. Chairman.
Thank you, Senator from Idaho. Now the senator from North Carolina.
Thank you, Mr. Chair. Judge Gorsuch, thank you for being here, and congratulations to you and to your family and friends who are either here present or watching on TV. I have had a couple of opportunities to be in your presence, and I really appreciate your calm, respectful demeanor, and I'm completely convinced you have an at-rest heart rate of about 4. Before I get into a few brief comments, and I want to be brief so that we can get through the comments and to the questions and move your nomination forward, I do think there's a little bit of confusion right now in terms of the comments made by some of my colleagues. This is not directed to you, Judge Gorsuch, but perhaps to those watching, to my members. The nominee before us today is not President Trump. The nominee before us today is not Leader McConnell. And it's not Judge Merrick Garland. It's one of the most extraordinarily talented and capable people that we could possibly have going to the Supreme Court. So I hope that this nomination hearing focuses on the one person before us who will go on, I believe, to fill the Supreme Court. This is a very important role that we have. I consider it one of the most important jobs that I have as a U.S. Senator. In the 2 years that I've been here, nothing rises to the level of importance of your nomination and the composition of the Supreme Court. You know, they last for life. They'll outlast most presidents and many senators. It affects all Americans, and they will be judgments that you will render that will last for decades. I I have no doubt that you have the qualifications. As a matter of fact, Senator Graham, I have associate myself with Senator Graham's comments. The only reason I didn't pursue your academic line of schools mainly had to do with admission requirements. But I appreciate the hard work that you did academically. I appreciate the hard work that you did as a litigator, and the work that you've done as a judge. I think it's truly extraordinary. I want to just go back to a comment or a conversation we had at my office. I mentioned to you in my office that I don't like activist judges, period. Conservative or liberal. It's not their role. The activists are us. We get elected. We go out to the people. We convince them that we want to make changes. We pass laws. Your job is to interpret them as a judge. And I believe that you responded to me, that you fully understood that your role fell squarely within Article 3 and that mine fell squarely within Article 1, and you saw the very bright line between the two. And I think you're going to do a great job. I think in your nomination acceptance, your quote was, "It is for Congress and not the courts to write new laws. It is the role of judges to apply, not alter, the work of the people's representatives." There have been some comments today made about cases that you've taken up, and I think they probably in some cases relate to the instances where you weren't really happy about the outcome. And I look forward to getting to some of those. I think that 2 or 3 have been mentioned that I intend to go through as a part of my review of your summary of jurisprudence. There's a number of examples where you interpreted the law. You did not become an activist. You didn't allow your empathy or your sympathy for a case to influence what your job is. I, for one, find that inspiring. And so, Mr. Chair, I'm going to keep my comments short, not for a lack of a desire to want to speak more about Judge Gorsuch's extraordinary background and history and qualifications for the job, because I desperately want the American people to get you to spend more time talking and let us spend more time listening so that they recognize the historic opportunity we have to confirm you to the Supreme Court. And I look forward to the remaining testimony.
Now we'll call on Hawaii.
Thank you, Mr. Chairman. Aloha, Judge Gorsuch.
Hello.
Thank you as well, of course, for being here. This hearing is about more than considering a nominee for the Supreme Court. It's about the future of our country. It's about the tens of millions of people who work hard every day, play by the rules, but don't get ahead. It's about the working poor who are one paycheck away from being on the streets. It's about Muslim Americans who are victims in a renewed wave of hate crimes, asking for protection from the courts. It's about women having the choice of what to do with their bodies, our bodies. It's about LGBTQ Americans who want the same rights as everyone else. For me, this hearing is about the people in this country who are getting screwed every single second, minute, and hour of the day. I got into public service to help these people, and my questions over the coming days will draw on their experience as well as my own. My story might be unique for a United States Senator, but it is a story that is familiar for millions of people in our country. When I was nearly 8 years old, my mom changed my life when she brought me to this country from Japan, fleeing an abusive marriage. Back then, there were no religious tests to determine who could immigrate to this country. There were no language requirements. You didn't need any special skills. If President Eisenhower pursued the same policies President Trump would like to, it's very possible I would not be here today. I always knew I wanted to give back to my state and my country, but never thought politics would be the path that I would choose. But the Vietnam War opened my eyes to how public service could create social change. I joined campus protests, questioned why we were sending so many young men to die in a far-off country. A small group of us decided that in order for things to change, we needed to do much more than protest. Many of us ran for office because we needed to take a seat at the table to be able to fight, help make lives better. It's why I'm here today. Over the past few months, I've heard from thousands of people who are deeply worried about their families, their kids, and the future of our country under the Trump administration. Many of them are worried about what will happen if you are confirmed to the bench. Apart from the legal analysis, whenever a case comes before a judge, it invariably involves real people, people who are often there because they have experienced the worst day in their lives. Whether they are victims of a crime, suffered a serious injury due to corporate malfeasance, or because they have lost their livelihood due to discriminatory behavior from their employer, each of them is looking to the courts to protect their interests and their rights. During our meeting, I was encouraged when you said that the purpose of Article 3 of the Constitution was to protect the rights of the minority through access to the courts. But as I have reviewed your opinions, I have not seen that the rights of minorities are a priority for you. In fact, a pattern jumps out at me you rarely seem to find in favor of the little guy. In Trans Am Trucking, your dissent argued that the company was justified in firing an employee who faced a choice between operating his vehicle in an unsafe manner and freezing to death in his truck. In a number of other cases, including Thompson School District, your decisions made it more difficult for families with special needs children to get the help they needed as the law intended. In Planned Parenthood v. Utah versus Herbert, your dissent was far too deferential to the decisions of a governor who based those decisions on unverified information. In Burwell v. Hobby Lobby, your opinion justified denying access to contraception based on the argument that corporations, like people, can hold religious beliefs. The facts in each of these cases might be different, but there is a clear pattern to your writing. You consistently choose corporations and powerful interests over people. But more than that, you have gone to great lengths to disagree with your colleagues on the 10th Circuit so that you can explain why some obscure or novel legal interpretation of a particular word in statute must result in finding for a corporation instead of an individual who has suffered real-life harm. This tendency demonstrates a commitment to ideology over common sense and indeed the purpose of the law, and it's deeply troubling. For example, again, in Trans Am Trucking, you fixated on the plain meaning of the word operate despite choosing a definition out of context and using it at odds of the clear purpose of the statute, which was a safety purpose. And in Longhorn Service Company, you found a difference between a floor hole and a floor opening in order to side with a corporation trying to avoid a citation for a safety issue. You found a difference in these terms between a floor hole and a floor opening that the rest of your colleagues on the 10th Circuit did not. Truly a case of a distinction without a difference. It's like arguing whether your nomination is because of a vacancy or an opening on the Supreme Court. These decisions affected not just the individuals who came before you. As a Supreme Court justice, your decisions will have lasting consequences for the rest of us. During the campaign, President Trump made it very clear that he had a series of litmus tests for his Supreme Court nominees. Over a 2-year period, the president said that his nominee must favor overturning Roe v. Wade, denying women access to health care on the basis of religious freedom, and upholding the Heller decision on guns, which the NRA believes prevents Congress, states, or local governments from passing common sense gun safety legislation. Each of these tests would have a profound impact on the lives of every American. Donald Trump's litmus tests for his Supreme Court nominees were crystal clear. In nominating you, Judge Gorsuch, I can only conclude that you met the president's litmus tests. Your ideological perspective, or as some would say here, your judicial philosophy on these issues matter, because if you are confirmed, you will have a lifetime appointment to the Supreme Court. In our courtesy meeting, you said you have a heart. So, Judge Gorsuch, we need to know what's in your heart. We need to understand how you will grapple with a number of important questions the court will be asked to consider in the years ahead. Will the court protect the rights of working people and our middle class, or side with corporations who want to dismantle organized labor in America? Will the court uphold the woman's constitutional right to choose or append decades of legal precedent to overturn Roe v. Wade? Will the court protect free and fair elections by stopping unfettered campaign spending or allow corporations and the ultra-rich to hijack our democracy with dark money? Will the court protect the right to vote for all Americans or allow states to use voter fraud as an excuse to disenfranchise vulnerable communities? Will the court protect our land, water, our earth, or gut decades of environmental regulations? Will the court protect access to our justice system or slam the courthouse door to all but the wealthiest among us? Judge Gorsuch, my colleagues, this is not merely a hearing to consider the confirmation of one Supreme Court justice. No, we are considering the affirmation of our country's values. The Supreme Court does not just interpret our laws. The Supreme Court shapes our society. Will we be just? Will we be fair? Will America be a land of exclusivity for the few or the land of opportunity for the many? Will we be the compassionate and tolerant America that embraced my mother, my brothers, and me many decades ago? Make no mistake, a Supreme Court vacancy isn't just another position we must fill in our federal judiciary. A Supreme Court vacancy is a solemn obligation we must fulfill for our future generations. Let's treat it as such. Thank you, Mr. Chairman.
Thank you, Senator from Hawaii. Now, the Senator from Louisiana.
Thank you, Mr. Chairman. How you doing, Judge?
Great. Thank you very much.
I walked by the Supreme Court the other day. I live nearby. And on that building, as many of us know, are the words justice, the guardian of liberty. Now, we live in cynical times, but I think those words are sacred to most Americans. And they really tell us everything we need to know about the importance of the United States Supreme Court, in my judgment. Without justice, without equal treatment by the law, liberty, which is why our country was founded, becomes an empty promise. So even though it's easy to look to elected officials, the president, Congress, governors, as the last protectors of liberty, we as Americans have entrusted that, I think we can all agree, to our Supreme Court. And that's why, in my judgment, this hearing is important. And that's why we need, if we can, to go beyond politics, beyond the person who lives in the White House, beyond whatever the issue of the day happens to be, and we need to try to truly understand our role in this process, which is to advise and consent. I hope we can focus on temperament, on legal philosophy, on legal reasoning, on qualifications, on experience. And for just a minute, I hope we can forget that we're all politicians here, you excluded, and focus instead on the judiciary and the role we get to play in affecting that most of American institutions, the United States Supreme Court. Now, I've had the opportunity to meet Judge Gorsuch and to read his work, and I like what I see. A former governor in my state once said of the then Attorney General, if you want to hide something from him, put it in a law book. You obviously don't have that problem. You appear to me to be exceptionally well qualified to be a Supreme Court justice. I was especially impressed with your doctorate of philosophy and law. That stuck out to me. A DPhil from Oxford is probably the most difficult terminal degree in the world. You also attended Columbia and Harvard, and they're satisfactory as well. I've read about 20 of your opinions. My favorite is A.M. v. Holmes. Your dissent was very short, 4 pages, but you packed a lot in those 4 pages. As far as I'm concerned, that dissent should be required reading in every law school. All I can say after reading those 20 opinions, some of which I agreed with, some of which I didn't, is that you write really, really well. Your opinions are engaging, whether you agree with them or not. Judge Gorsuch is direct, clear, concise, you're collegial, and you have a clean grasp of the law. There's no boilerplate language that lawyers often put in their briefs, and sometimes judges do as well. I also might add that another thing struck me about your opinions. You show concern for the parties. You use their names. You don't refer to the parties as appellants or appellees or respondents. You call them by their name. And I like that. Judge Gorsuch's respect for judicial independence and for precedent, in my judgment, is apparent in all of his opinions. He's an unyielding supporter of the separation of powers, and I believe that he genuinely understands and values the role of the judiciary as a check on both the legislative and executive branches. And that's very, very important to me. As are we all, I'm rather fond of the Constitution and the structure that it creates, separating powers so no branch of government can bully another or bully the American people. One of the main purposes of the United States Constitution, in my opinion, is to tell us when to stop, to reaffirm that the authority of the state over its people is limited and it is finite. Let me be blunt. I'm looking for a judge, not an ideologue. I don't want somebody on the United States Supreme Court who is blinded by ideology. I'm not interested in people who want to use the judiciary to advance their own personal policy goals, whether they are to the right or to the left. I want a judge to apply the law as it is, as best he understands it, not to try to reshape the law as he wishes it to be. I also want a person who's intellectually curious, who is earnest in his desire to rule fairly, and who is willing to really fight for his view of justice. I guess what I want is a cross between Socrates and Dirty Harry. And I believe you just might be that person. Let me say one final thing. I'm an officer of the court. None of the, as a lawyer, as are you, none of the questions that I'm going to ask you today are designed to trick you, as if I could. Nor are they designed to suggest that you should violate Canon 3A6 of the Code of Conduct for United States judges, which says a judge should not make public comment on the merits of a matter pending or impending in any court. Nor will my questions be designed to cause you to violate Rule 2.10A of the American Bar Association Model Code of Judicial Conduct, which, as you know, states, a judge shall not make any public comment, any public statement that might reasonably be expected to affect the outcome or impair the fairness of a matter pending or impending in a court. And finally, nor will my questions be designed to ask you to violate Rule 2.10B of the American Bar Association Model Code of Judicial Conduct, which states, a judge shall not, in connection with cases, controversies, or issues that are likely to come before the court, make pledges, promises, are commitments that are inconsistent with the impartial performance of the adjudicative duties of his judicial office. If you think any of my questions today or tomorrow or later this week cross those lines, I hope you'll speak up so we can talk about it. Thank you, Mr. Chairman.
Thank you, Senator from Louisiana. Now it's your opportunity to take a rest while other people say what I imagine will be very good things about you. So we're going to call to the bench Senator Bennet and Gardner and Neal Katyal. We'll take Senator Bennet and Gardner first. Mr. Katyal was acting Solicitor General for President Obama. I know you have busy schedules, and I want to thank you for taking time to introduce our nominee today. So would you depart from the table, and then
You don't have to ask me twice, Mr. Chairman.
Okay, and then we'll have the other people come. Just stand at ease for just a couple minutes here. It won't take very long.
Minute and a half.
Well. It's my understanding that you two have kind of decided that Senator Gardner should go first, and then Senator Bennet, and then we'll have, when you folks depart the table, we'll have Mr. Katyal to come to the table. So, Senator Gardner.
Thank you, Mr. Chairman. Chairman Grassley, Ranking Member Feinstein, I would like to begin by thanking all of you at the committee for your hard work during these hearings in the next several days. Today, it's with great pleasure that I introduce, along with my colleague and fellow Coloradan, Senator Michael Bennet, and share my strong support for our outstanding Supreme Court nominee, Judge Neal Gorsuch. If you've ever had the privilege of visiting Confluence Park in Denver, you'll notice a plaque bearing a poem by Colorado Poet Laureate Thomas Hornsby Farrell. It's a poem known as Two Rivers, describing the settlement of the West. I wasn't here, yet I remember them. That first night long ago, those wagon people who pushed aside enough of the cottonwoods to build our city where the blueness rested. Where the optimistic blueness of our Colorado skies rests against the mountains and the plains, we are reminded about how incredibly diverse our great nation is, its people and its geography. Judge Gorsuch's nomination helps recognize that indeed there are highly qualified jurists west of the Mississippi River. Judge Gorsuch is a fourth-generation Coloradan, skier, fly fisher, serving on a court that represents 20% of our nation's landmass, whose family roots reflect the grit and determination that built the West. Once confirmed, Mr. Gorsuch will join Justice Byron White and be only the second Coloradan to have served on the United States Supreme Court, and the only Coloradan to be serving on the U.S. Supreme Court who did not break the NFL rushing record. But the good news is today he does have the endorsement of number 7, John Elway of the great Denver Broncos. Should he be confirmed, Judge Gorsuch will make history as he represents the first-generation ex-justice of the United States Supreme Court, the emerging generation of American leadership. Judge Gorsuch was confirmed to the 10th Circuit Court unanimously by voice vote in 2006. 11 years ago, Senator Graham presided over an empty committee room, empty dais. What a difference a court makes. But when you look at his record, his writing, his statements, it's easy to see why Judge Gorsuch has such overwhelming appeal. Judge Gorsuch is not an ideologue. He's a mainstream jurist who follows the law as written and doesn't try to supplant it with his own personal policy preferences. As he said, personal politics or policy preferences have no useful role in judging. Regular and healthy doses of self-skepticism and humility about one's own abilities and conclusions always do. Judge Gorsuch is not an activist judge, but rather a faithful adherent to and ardent defender of our Constitution. He's an originalist, as Justice Kagan even described herself in her confirmation hearing to the U.S. Supreme Court. Judge Gorsuch recognizes that the judiciary is not the place for social or constitutional experimentation, and that efforts to engage in such experimentation delegitimize the court. As he said, this overwhelming addiction to the courtroom as the place to debate social policy is this overweening addiction to the courtroom as the place to debate social policy is bad for the country and bad for the judiciary. As a society, we lose the benefit of give and take of the political process and the flexibility of social experimentation that only the elected branches can provide. Judge Gorsuch has a deep appreciation and respect for the constitutional principles of federalism and the separation of powers prescribed by our founding fathers. As he stated, a firm and independent judiciary is critical to a well-functioning democracy. Judge Gorsuch understands the advantage of democratic institutions and the special authority and legitimacy that come from the consent of the governed. As he said, judges must allow the elected branches of government to flourish, and citizens, through their elected representatives, to make laws appropriate to the facts and circumstances of the day. Judge Gorsuch appreciates the rule of law and respects the considered judgment of those who came before him. As he said, a good judge will seek to honor precedent and strive to avoid its disparagement or displacement. It's this appropriate temperament, this fidelity to the Constitution, this remarkable humility that has made Judge Gorsuch a consensus pick among Colorado's diverse legal and legislative communities. Former Colorado Senator, Democrat Ken Salazar, in praising Judge Gorsuch's temperament during his circuit court confirmation, said, "A judicial nominee should have a demonstrated dedication to fairness, impartiality, precedent, and the avoidance of judicial activism from both the left and the right. I believe that Mr. Gorsuch meets this very high test." Jim Lyons, a prominent Colorado lawyer and former advisor to President Bill Clinton, said, "Judge Gorsuch's intellect, energy, and deep regard for the Constitution are well known to those of us who have worked with him and have seen firsthand his commitment to basic principles. Above all, this independence, fairness, and impartiality are the hallmarks of his career and his well-earned reputation." Colorado's former Democratic Governor Bill Ritter and former Republican Attorney General John Suthers jointly said, "It's time to use this confirmation process to examine and exalt the characteristics of a judge who demonstrates that he or she is scholarly, compassionate, committed to the law, and will function as part of a truly independent, apolitical judiciary. Judge Gorsuch fits that bill." According to the Denver Post, Marcy Glenn, a Denver attorney and Democrat, recalls 2 cases before Gorsuch in which she represented underdogs. And I quote Marcy Glenn, "He issued a decision that most certainly focused on the little guy." Judge Gorsuch has a consistent record of applying the law fairly, and his reputation among his peers and lawmakers is evidence of it. For all of these reasons cited today, I'm certain Judge Gorsuch will make Colorado proud, and that his opinions will have a positive impact on this country for generations to come. I look forward to Judge Gorsuch receiving a fair hearing, and after that, to working with my distinguished colleagues on both sides of the aisle to expeditiously confirm his nomination. Thomas Hornsby Farrell wrote another poem, this one memorialized in a mural on the walls of the Colorado Capitol Rotunda. It ends with these words: "Beyond the sundown is tomorrow's wisdom. Today is going to be long, long ago." The wisdom of Neal Gorsuch, guardian of the Constitution, will serve our nation well for generations to come. Mr. Chairman, committee members, thank you.
Thank you, Senator Gardner. Now, Senator Bennet.
Thank you, Mr. Chairman. I want to thank you and the committee for allowing me to be here today. It's a distinct privilege to be here with my colleague, Senator Gardner from Colorado, to introduce Judge Neal Gorsuch, a son of Colorado, born and raised in Denver, with a distinguished record of public service, private practice, and outstanding integrity and intellect. And I welcome as well his wife, Louise, who met the judge during their studies at Oxford and who moved from the United Kingdom to Colorado, where they now live with their 2 daughters in Boulder. Senator Gardner has done a great job summarizing Judge Gorsuch's professional background. His experience and his approach to his work has earned him the respect of the bench and the bar in our state. Judge Gorsuch's family has deep roots in Colorado. His grandfather grew up in an Irish tenement in Denver and began supporting the family at the age of 8. His other grandfather was a lawyer who worked his way through law school, serving as a streetcar conductor in Denver. His grandmother was one of the first women to graduate the University of Denver in the 1920s. As a person and as a lawyer, Judge Gorsuch exemplifies some of the finest qualities of Colorado, a state filled with people who are kind to one another, who by and large do not share the conceit that one party or one ideology is all right and the other all wrong, and who are conscious of the legacy we owe the generations who forged our state out of a Western territory of the United States. If confirmed, Judge Gorsuch will be the first justice since Sandra Day O'Connor from the West. No less an authority than Justice Scalia observed this lack of representation when he wrote in dissent that the court has, quote, not a single genuine Westerner, and then added with parentheses, California does not count. And with respect to our ranking member, I think I speak for my colleague from Colorado, that on this point, and perhaps this point alone, he, I, and Justice Scalia are in agreement. I'm also here because I believe the Senate has a constitutional duty to give fair consideration to this nominee, just as we had a duty to consider fairly Judge Merrick Garland, President Obama's nominee to fill this vacancy. I am not naive about the reasons the Senate majority denied Judge Garland a hearing and a vote. The Senate's failure to do its duty with respect to Judge Garland was an embarrassment to this body that will be recorded in history and in the lives of millions of Americans. And it is tempting to deny Judge Gorsuch a fair hearing because of the Senate's prior failure. But, Mr. Chairman, two wrongs never make a right. The Supreme Court is too important for us not to find a way to end our destructive gridlock and bitter partisanship. In my mind, I consider Judge Gorsuch as a candidate to fill the Garland seat on the Supreme Court. And out of respect for both Judge Garland and Judge Gorsuch's service, integrity, and commitment to the rule of law, I suggest we fulfill our responsibility to this nominee and to the country by considering his nomination in the manner his predecessor deserved but was denied. Mr. Chairman, there's a second cloud that hangs over this confirmation hearing. It is President Trump's reckless attacks on the judiciary. These attacks, like the President's attacks on the free press, have no precedent in the history of our republic. The independence of our courts is an essential strength of our democracy. Attacking the judicial branch erodes the public confidence that gives force to their judgments. It damages the very foundation of our constitutional system. Disagreeing with a court's decision is acceptable. Disparaging a judge is always wrong. I have no doubt that, unlike the President, Judge Gorsuch has profound respect for an independent judiciary and the vital role it plays as a check on the executive and legislative branches. I may not always agree with his rulings, but I believe Judge Gorsuch is unquestionably committed to the rule of law. Mr. Chairman, it is customary for senators to introduce nominees from their home state, and I'm not here today to take a position or persuade any of our colleagues how to vote. That is a matter of conscience for each of us. I am keeping an open mind about this nomination and expect this week's hearings will shed light on Judge Gorsuch's judicial approach and views of the law. Like many Americans, I look forward to the committee's questions and the testimony from the nominee. And as one of two Americans privileged to represent the state of Colorado in the United States Senate, I am here this afternoon to uphold a tradition with the hope that in some small way it helps restore the Senate's strong history of comity and cooperation, especially in our nation's most difficult times. Whatever the results of this hearing, we senators must respond in some way to the expectations of most Coloradans and most Americans who are eager for us to work together and to treat each other with respect, particularly when it comes to extraordinarily important decisions like this one. Thank you, Mr. Chairman.
Bennet, Senator Gardner, thank you very much. And you're dismissed, and we will have Mr. Katyal come to the table now. And as I said, he was acting Solicitor General in the previous administration. Thank you very much, and you may proceed at your will.
Feinstein, it's my privilege to introduce Judge Gorsuch to this honorable committee. Unlike Senators Gardner and Bennet, I am unfortunately only a part-time Colorado resident, but I'm very proud to see this distinguished judge with an excellent first name be nominated for this position. Judge Gorsuch was born in Denver in 1967, the fourth generation of his family to hail from Colorado. He attended Columbia and Harvard Law School and later clerked for Judge David Santel and Justices White and Kennedy. Judge Gorsuch then spent a decade at a law firm, and after serving in a leadership role at the Justice Department, he returned to Colorado as a federal judge. I suppose the fly fishing in D.C. just wasn't good enough. In the few minutes I have, I'd like to bring into my world of litigating cases before the Supreme Court of the United States. I've argued 32 cases over the last decade, 2 more arguments coming next month. My arguments have been on behalf of the most diverse client base imaginable: death penalty inmates, states, the federal government, Native American tribes, our nation's largest corporations, what the great senator from Hawaii called the so-called little guy, and everyone in between. I can tell you the one thing you really want when you're in front of the court is just an opportunity to be treated fairly, to have your position listened to, not caricatured, and treated with the gravity it deserves, to have jurists who work day and night to get the right answer, not motivated by party or politics, but by justice. And honestly, that's how our Supreme Court works. Every time I'm up there, I get a lump in my throat because I see it firsthand, and I wish the court would televise its proceedings so that the American public would see what I get to see every day. And it is because of that deep need for fairness on the court, like like so many Americans, are outraged that Merrick Garland does not sit on the court today. I've had the pleasure of appearing before him, and he's grilled me once for over an hour. Indeed, I think maybe using the word pleasure is probably the wrong word to use. Garland's brilliance, his experience, his fairness, and meticulous attention to detail make him perhaps the most qualified nominee ever to have been named to the Supreme Court. And there's no doubt in my mind that if Merrick Garland had been confirmed and another vacancy had opened up, Judge Gorsuch would be sailing through this body with something close to a 100-0 vote. It is a tragedy of national proportions that Merrick Garland does not sit on the court. And it would take a lot to get over that. Indeed, there's less than a handful of people that the president could have nominated to even start to rebuild that loss of trust. But in my opinion, Neal Gorsuch is one. I say that knowing many people in my party will disagree and think the damage cannot be repaired no matter who the nominee is. I can understand that sentiment. For those folks, there's nothing I can say about the nominee to make things right. But if you haven't closed your mind to the possibility of a new nominee, despite the undeserved and unprecedented treatment of Merrick Garland, I'd like to tell you a bit about Judge Gorsuch. There's a reason why our Supreme Court bar has lined up behind Judge Gorsuch. There's a reason why the American Bar Association has given him the highest rating. I've seen Judge Gorsuch in action, and I've seen him hearing cases and studied his written opinions. This is a first-rate intellect and a fair and decent man. Judge Gorsuch and I served together on the Federal Appellate Rules Committee. It's complicated work and, quite honestly, not the sort that most people find particularly interesting, but the judge commits himself to it fully, and his work reflects his commitment to resolving disputes according to established standards. That is, the judge's work reflects his dedication to the rule of law. The judge's commitment to the rule of law would endear him well to our founders. Ours is a government of laws, not of men and women. That principle is the essence of constitutional government and the foundation of our freedoms. Yet if ours is to remain a government of laws, the subject of the laws must not be allowed to interpret it for themselves. No one can be a judge in his own cause. The founders forged the judiciary as independent of the executive and legislative branches. Quote, "The complete independence of the courts of justice is peculiarly essential in a limited constitution," Alexander Hamilton wrote in Federalist 78. "Without this, all the reservations of particular rights or privileges would amount to nothing." We live in a unique time. The current president has displayed open contempt for the courts, attacking judges who disagree with him and even questioning their legitimacy and motives. Judges who have questioned the president's authority have had to be placed under increased scrutiny and protection because of the reaction among some members of the public. Between the president's attacks on the judiciary and his controversial policies, he seems intent on testing the independence and integrity of our court system. And that brings me back once again to my support of Judge Gorsuch. As a judge, he's displayed a resolute commitment to the rule of law and the judiciary's independence. Even those who disagree with him concede the judge's decisions are meticulously crafted and grounded in the law and our Constitution. And when the judge believes the government has overstepped his powers, he's willing to rule against it. It's very difficult to make the transition to justice. I've seen Justices Kagan and Breyer go through it firsthand. It's not just the massive power all of a sudden that one wields. It's also the glare of the spotlight and awareness of becoming part of history, and most important, getting along with 8 new colleagues who'll be at your side for decades. To do this well is hard. It requires equal parts and equal servings of humility and ability. That's what Justices Kagan and Breyer brought to their transitions and what Judge Gorsuch has. In short, to make up a word, Judge Gorsuch has humility and ability. In sum, Judge Gorsuch and I come from different sides of the political spectrum. We disagree about many things, but we agree on the most important things, that all people are equal before the law, and that a judge's duty is to uphold the law and uphold these principles, and the Constitution above all. The judge has done that during his time on the bench, and I know he'd continue to do so as a justice on the Supreme Court. It's therefore my honor to recommend that his nomination be reported favorably to the Senate.
A busy schedule. Thank you for being here. We'll wait until you want to change everything that you have to do.
Put a new name.
Judge, you come forward, and before you sit, would you raise your right hand to be sworn? Do you affirm that the testimony you're about to give to the committee be the whole truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please be seated, and you may tell us what you want us to hear at this point.
Mr. Chairman, Senator Feinstein, members of the committee, I am honored and I am humbled to be here. Since coming to Washington, I've met with over 70 senators. You've offered me a warm welcome and wise advice. Thank you. I also want to thank the President and the Vice President. They and their teams have been so gracious to me, and I thank them for this honor. I want to thank Senators Bennet and Gardner and General Katyal for their kind introductions, reminding us that long before we're Democrats or Republicans, we're Americans. Sitting here, I'm acutely aware of my own imperfections, but I pledge to each of you and to the American people that if I am confirmed, I will do all my powers permit to be a faithful servant of the Constitution and laws of this great nation. Mr. Chairman, I could not even attempt to do this without Louise, my wife of more than 20 years. The sacrifices she has made and her open and giving heart, they leave me in awe. I love you so much. We started off in a place very different than this one. Tiny apartment, little to show for it. When Louise's mother first came to visit, she was concerned by the conditions, understandably. As I headed out the door to work, I'll never forget her whispering to her daughter, in a voice I think intended to be just loud enough for me to hear, "Are you sure he's really a lawyer?" To my teenage daughters watching out west, bathing chickens for the county fair, devising ways to keep our determined pet goat out of the garden, building a semi-functional plyboard hovercraft for science fair, driving 8 hours through a Wyoming snowstorm with high school debaters in the back arguing the whole way. These are just a few of my very favorite memories. I love you girls impossibly. To my extended family, here and across Colorado, when we gather, it's dozens of us. We hold different political and religious views, but we are united in our love. And between the family pranks and the pack of children running rampant, whoever's hosting is usually left with at least one drywall repair. To my parents and grandparents, they're no longer with us, but there's no question on whose shoulders I stand. My mom was one of the first women graduates of the University of Colorado Law School. As the first female assistant district attorney in Denver, she helped a program to pursue deadbeat dads. And her idea of daycare sometimes meant I got to spend the day wandering the halls or tagging along behind the police officers. She taught me that headlines are fleeting. Courage lasts. My dad taught me that success in life has very little to do with success. Kindness, he showed me, is a great virtue. He showed me, too, that there are few places closer to God than walking in the wilderness or wading a trout stream, even if it is an awfully long drive home with the family dog after he encounters a skunk. To my grandparents, as a boy, I could ride my bike to their homes. They were a huge influence. My mom's father, poor and Irish, worked to help support his family as a boy after losing his own dad. But the nuns made sure he got an education and he became a doctor. Even after he passed away, I heard stories for years from grateful patients who recalled him kneeling by their bedsides so they might pray together. His wife, my grandmother, grew up on a Nebraska farm where an ice box wasn't something you plugged into the wall, but something you lowered into the ground. With 7 children, she never stopped moving, and she never stopped loving. My dad's father made his way through college working on Denver's trolley cars. He practiced law through the Great Depression. And he taught me that lawyers exist to help people with their problems, not the other way around. His wife came from a family of pioneers. She loved to fish. And she's the one who taught me how to tie a fly. I want to thank my friends, so many of whom are here, liberals and conservatives and independents from every kind of background and belief. Many hundreds have written this committee on my behalf, and I'm truly touched by their support. They have been there for me always. Not least when we recently lost my Uncle Jack, a hero of mine, and a lifelong Episcopal priest. He gave the benediction when I took an oath as a judge 11 years ago. I confess I was hoping he might offer a similar prayer soon. As it is, I know he is smiling. I want to thank my fellow judges across the country. Judging is sometimes a lonely and hard job. But I have seen how these men and women work, how hard they work, with courage and collegiality, independence and integrity. It's their work that helps make real the Constitution and laws of the United States for all of us. I want to thank my legal heroes. Byron White, my mentor, a product of the West. He modeled for me judicial courage. He followed the law wherever it took him, without fear or favor to anyone. War hero, Rhodes Scholar, and yes, the highest paid NFL football player of his day. In Colorado today, there's God, there's John Elway, and there's Peyton Manning. In my childhood, it was God and Byron White. I also had the great fortune to clerk for Justice Kennedy. He showed me that judges can disagree without being disagreeable, that everyone who comes to court deserves respect, that a case isn't just a number or a name, but a life's story, and a human being with equal dignity to my own. Justice Scalia was a mentor, too. He reminded us that words matter, that the judge's job is to follow the words that are in the law, not replace them with those that aren't. His colleagues cherished his great humor, too. Now, we didn't agree on everything. The justice fished with the enthusiasm of a New Yorker. He thought the harder you slapped the line on the water, somehow more the fish would love it. Finally, there's Justice Jackson. He wrote so clearly that everyone could understand his decisions. He never hid behind legal jargon. And while he was a famously fierce advocate for his client when he was a lawyer, he reminded us that when you become a judge, you fiercely defend only one client, the law. By their example, these judges taught me about the rule of law and the importance of an independent judiciary, how hard our forebears worked to win these things, how easy they are to lose, how each generation must either take its turn carrying the baton or watch it fall. Mr. Chairman, these days we sometimes hear judges cynically described as politicians in robes, seeking to enforce their own politics rather than striving to apply the law impartially. But if I thought that were true, I'd hang up the robe. The truth is, I just don't think that's what a life in the law is about. As a lawyer for many years working in the trial court trenches, I saw judges and juries, while human and perfect, striving hard every day to fairly decide the cases I put to them. As a judge now for more than a decade, I've watched my colleagues spend long days worrying over cases. Sometimes the answers we reach aren't the ones we personally prefer. Sometimes the answers follow us home at night and keep us up. But the answers we reach are always the ones we believe the law requires. And for all its imperfections, I believe that the rule of law in this nation truly is a wonder, and that it's no wonder that it's the envy of the world. Of course, once in a while we judges do disagree. But our disagreements are not about politics, but about the law's demands. Let me offer an example. The first case I wrote as a judge to reach the Supreme Court divided 5-4. The court affirmed my judgment with the support of Justices Thomas and Sotomayor, with Justices Stevens and Scalia in dissent. Now, that's a lineup some might think unusual. But actually, it's exactly the sort of thing that happens quietly, day in and day out, in the United States Supreme Court and in the courts across this country. I wonder if people realize that Justices Thomas and Sotomayor agree about 60% of the time, or that Justices Scalia and Breyer agreed even more often than that, all in the very toughest cases in our entire legal system. And here's another example about my record. Over the last decade, I've participated in over 2,700 appeals. Often these cases are hard too. Only about 5% of all federal lawsuits make their way to decision in a court of appeals. I've served with judges appointed by President Obama all the way back to President Johnson. And in the 10th Circuit, we hear cases from 6 different states covering 2 time zones and 20% of the continental United States. But in the West, we listen to one another respectfully. We tolerate, we cherish different points of view, and we seek consensus whenever we can. My law clerks tell me that 97% of those 2,700 cases I've decided were decided unanimously, and that I've been in the majority 99% of the time. That's my record, and that's how we do things in the West. Of course, I make my share of mistakes too. As my daughters never tire of reminding me, putting on a robe does not make me any smarter. And I'll never forget my first day on the job. Carrying a pile of briefs up the steps to the bench, I tripped on the hem of my robe, and just about everything went flying. But troublesome as the robe can be, the robe does mean something to me, and not just that I can hide the coffee stains on my shirt. Putting on a robe reminds us judges that it's time to lose our egos and open our minds. It serves, too, as a reminder of the modest station we judges are meant to occupy in a democracy. In other countries, judges wear scarlet, silk, ermine. Here, we buy our own plain black robes. And as Senator Sass knows, I can attest the standard choir outfit at the local uniform supply store is a pretty good deal. Ours is a judiciary of honest black polyester. When I put on the robe, I'm also reminded that under our Constitution, it's for this body, the people's representatives, to make new laws, for the executive to ensure those laws are faithfully executed, and for neutral and independent judges to apply the law in the people's disputes. If judges were just secret legislators, declaring not what the law is, but what they would like it to be, the very idea of a government by the people and for the people would be at risk. And those who came before the court would live in fear, never sure exactly what the law requires of them except for the judge's will. As Alexander Hamilton said, liberty can have nothing to fear from judges who apply the law, but liberty has everything to fear if judges try to legislate too. In my decade on the bench, I've tried to treat all who come before me fairly and with respect, and afford equal right to poor and to rich. I've decided cases for Native Americans seeking to protect tribal lands, for class actions like one that ensured compensation for victims of a large nuclear waste pollution problem produced by corporations in Colorado. I've ruled for disabled students, for prisoners, for the accused, for workers alleging civil rights violations, and for undocumented immigrants. Sometimes, too, I've ruled against such persons. My decisions have never reflected a judgment about the people before me, only a judgment about the law and the facts at issue in each particular case. A good judge can promise no more than that, and a good judge should guarantee no less. For a judge who likes every outcome he reaches is probably a pretty bad judge, stretching for policy results he prefers rather than those the law compels. Mr. Chairman, as a student many years ago, I found myself walking through the old Granary burial ground in Boston. It's where Paul Revere, John Hancock, and many of our founders are buried. And there I came across the tombstone of a lawyer and judge who today is largely forgotten, as we're all destined to be soon enough. His name was Increase Sumner, and written onto his tombstone over 200 years ago was this description of the man. As a lawyer, he was faithful and able. As a judge, patient, impartial, and decisive. In private life, he was affectionate and mild. In public life, he was dignified and firm. Party feuds were allayed by the correctness of his conduct. Calumny was silenced by the weight of his virtues, and rancor softened by the amenity of his manners. Mr. Chairman, those words stick with me. I keep them on my desk. They serve for me as a daily reminder of the law's integrity, that a useful life can be led in its service, with the hard work it takes, and an encouragement to good habits when I fail and when I falter. At the end of it all, I could ask for nothing more than to be described as he was. And if confirmed, I pledge to you that I will do everything in my power to be that man.
Thank you, Judge. I have just a few words to say, to read, but before I do that, we will convene tomorrow at 9:30. Each person will have 30-minute rounds. I want to finish the first round tomorrow, so not taking into consideration any of the judges' needs to get away from the table for time to eat and do other things. I would suggest that we have at least 10 hours of work to do in addition to whatever the judge needs. So I ask you to be prepared for that. The way I would like to do it, since each person has a half hour, if you start your last question before the time runs out, I'll ask the judge to give a short answer, but I think we have to move on very quickly and get it done. and then the next day we have 20-minute rounds, and there'll be as many rounds as people need, because I'd like to get done by Wednesday night. And if we can get it so I can get to bed at 9 o'clock like I like to, I would appreciate it. We have questions for the record being due at 5 p.m. This timeline is consistent with how we've handled past Supreme Court nominations. I want everybody to know that now, so that members and their staffs can be working on written questions throughout the week. With that, we will recess until 9. I'm sorry.
5 p.m. when?
Oh, I'm sorry. Friday at 5 p.m. Yeah. With that, the meeting's adjourned.